Right? But this is a group 2 matter. The matter is yet to be admitted. Matter was appearing before Justice Revision Bench presided by Justice Tapoboth Chakraborty before vacation, and it was directed to list after vacation. Possibly, but this court doesn't have jurisdiction. I don't know how come this matter has been listed
86.
here. 86.
MAT 1565.
1565, yes. I don't know why this was supposed to be listed after vacation there.
Just check up whether it is wrongly listed or not. You give the number.
It's a group 2.
They will check up.
My lord, with the leave of Honorable Justice Vishwas, my lord, may I leave to mention one matter assigned to your lordship, my lord. I have filed one application that may be listed along with the that application is filed in a first appeal, my lord. It was assigned to your lordship, my lord.
For application for
early disposal of the appeal, my lord.
first appeal.
First appeal assigned matter.
Assigned before this bench.
Before your lordship, my lord.
Mention after 1 week. You just wait. After the next week, you mention.
17th of hearing by the Honorable Chief Justice Revision Bench. But thereafter, my lord, that determination has been changed. Now you are before lordship the determination.
There is an order fixing it for hearing on 17th.
On 17th.
If there is an order, it will be listed. Take it. Find out if there is order, then you list it.
This is
After notice I am mentioning, my lord, this matter was heard by the coordinate bench, wherein, my lord, a direction was passed that the matter will be taken up today at 2 p.m. But the matter is not appearing, my lord. This is the order, my lord. We have served notice on the other side.
It can't be taken up today.
And may it be listed today, next week.
It's for hearing.
Yes, short point involved.
After next week. After next week. We are compiling the hearing matters separately. We'll fix a day for hearing. Therefore, we are saying. Yes.
This matter is item number 111, lad. The last direction was passed on 13th August 2024 by this court, lad, directing them to file affidavit, lad. They did not file affidavit, but till date the matter was not taken up. Thereafter, lad, can it be, lad, has already been retired. Lad, I have sought for regulation. There are other employees lad, will be retiring soon, lad.
No priority.
I have sought for regularization and other constitutional benefits, lad. Unless the matter.
Sorry. Yes.
Any day as per lordship's convenience in the next week.
It will come. It is on the list. Not
it
very.
Is the list for last 1 year.
It has been called twice in the last week.
Last week.
This entire list. Yes. Yes.
I try to mention matter for application matter.
What is the application for?
6 matter. 6 new application.
New.
Matter.
What is the date fixed by the office for listing of the matter?
Wrongly, it was fixed before the Honorable Chief Justice matter. On 7th matter, it was fixed matter in the press.
So it was on the list?
No. No.
What are you saying? We don't understand. What are you saying?
That service matter, my lord, wrongly filed my lord before the Honorable Chief Justice matter.
You want inclusion? It will be included in the give. Give it. Give it. Section 5. Both in the same case.
Was in abroad. As matter was listed on appeared for a record. But now
applications are not listed. Give the slip. Applications will be listed next. 17th. 17th. There is a notice which was been published last week. You know the bench will not be available. You know that urgent matters are assigned. Today you have to mention on the last day. Why? You could have done this yesterday. You could have done this on Monday. It is already lapsing today. What is the point in having it tomorrow? Who is for the other side? Who is the learned advocate appearing? Can you ask him? You mentioned before rising for lunch. You intimate him and you mention before rising for lunch.
Lordship, on extreme urgency, Lordship, I'm praying for leave to file the appeal without the certified copy. Lordship,
Appeal.
yes, Lordship, in respect of Group 7 matter, Lordship, I had applied for the certified copy before Puja vacation, but it has not been received. I have duly.
What is the issue?
Lordship, regarding state carriage permit. The order has been passed in March, but Lordship, contempt application has been filed. The matter
What order has been passed in
The
March?
Lordship, to grant state carriage permit in respect of the private respondent against which uh, uh, we want to file an appeal.
In March.
Lordship.
And now you are filing an appeal.
Lordship, there was some delay in the process regarding, but Lordship, the matter is extremely urgent as the contempt application is pending. Lordship.
Pending, so what? Many matters contempt is pending.
Lordship, may
You file it. Why you have slept over the matter for months together? Whenever you wake up, it becomes urgent. And then we should allow it. It's a March order, sir. It's not an order passed last month or within 10 days.
Lordship, I understand.
You are knowing about it.
Lordship, but the application for certified copy had been made before Puja. We have not before Puja vacation.
You go and see, you will get it. File it with the certified copy.
Contempt application, my lord.
Yes.
Contempt application, may I be permitted to make it?
What do you want? Listing of the contempt? The contempt of the matter of this bench?
Yes, sir. Judgment was passed by my lord and Honorable Justice Vibhash Ranjan Dey. But my lord, Vibhash Ranjan Dey has retired, my lord.
Very well, give it. Give
May I permit it to leave?
Monday week.
Leave file without.
Monday week.
Take a leave, my lord, leave file without the. Leave file the appeal, my lord, without the certified copy, my lord. Order passed 10th November 2025. My lord, this is the election process, my lord. For post of constable. This is a petitioner.
Election of for the post of constable.
Yes, my lord. This is the disqualified on the ground. Selection process, my lord.
Huh?
Selection process.
Post selection.
Yes, my lord. Ground for height of petitioner, my lord. It is entitled the benefit of surrounding the uniform benefits rule.
What happened? What has the
Exam started, my lord, 12. So, my lord,
what is your relief in the writ petition?
my lord, the petitioner disqualified, my lord, for rejected the for the height, my lord, 169.7 and 169.5, my lord.
And the writ has been dismissed.
Yes, my lord.
When it has been dismissed?
Dismissed, my lord, 10th 11 2025.
Monday week listed. You have given undertaking for filing the certified copy.
Item number 1.
For the last occasion, there was a direction upon the learned advocate appearing for the state. So the reasons why the reply was not filed before the learned tribunal to the original application. The original application is pending since 2022.
Today it is coming up for the first time.
No, my lord, it's coming up for the second time.
There is no order, earlier order?
My lord has not passed the order, my lord, because they took time to seek instruction on this. My lord, this was those two analogous matter where I had challenged the show cause.
Oh, that one matter was disposed of.
This is the second matter which was interconnected.
It is still pending.
It is still pending, and now Lordship knows the position of the Honorable Tribunal. It is vacant.
And what is the relief in this case?
My lord, I am seeking it. I am seeking the direction for the expeditious disposal of this matter with a in a time-bound manner.
No, what is the prayer before the tribunal in the original?
My lord, before the tribunal, my prayer could be found from page 23.
Yes, 23 or 26.
My lord, 26. An order to issue thereby setting aside quashing the order
Where
sheet
is that order? 9/8/21?
9th August 2021. 9th August 2021, Lordship could be found. It is in page 20, page 30. Order dated 9th August 2021. By that order, my lord, they had refused to accede to my prayer for promotion, for which they were directed to consider it by the learned tribunal earlier occasion.
It's a promotion matter.
Yes, my lord.
What is the urgency?
My lord, the urgency is that,
Considered.
Lordship, in that case, Lordship, I will be beseeching your Lordship to direct them to keep one post vacant in
Why?
so that in that case, so that
This has already, this is something which was due in 20 or something like that.
I am pursuing it, my lord.
But where's the question of keeping a post vacant? You have, that was long back.
My lord, so direct them
It's not a
because it is
recruitment
not
process
my
that
fault.
will
It
direct.
is not my fault. I was within the time.
Whatever it is, now it is, all that interim scope is over.
Well, kindly direct them to dispose it in a time-bound manner, and so that even the state can perform their role to fill up the post of the tribunal.
That
They have
is-
also not filed the reply.
That is beyond the scope of the writ petition, directing them to constitute the tribunal list, not the scope of the writ petition.
Well, they have not filed the reply, Lordship, it will be
Therefore,
reflected from the orders. Lordship, kindly come to the orders.
Yes, they may not have.
That in that case, Lordship, kindly it starts from the
When
last order
if at all you are held entitled to the promotion, you can get everything. There's nothing that irreparable injury is going to be caused.
the first direction was on 18/2/2020.
Maybe.
And that particular order, there was a direction. And thereafter, Lordship, kindly come to order dated 8/4/2022, when Mr. M.N. Royal and an advocate counsel appearing for the state respondents prayed for adjournment to obtain instruction from the department. Thereafter, Lordship, the order dated 14/6/2022. It says the present application in service of notice in terms of Rule 11. The respondents have already appeared through their learned counsel to contest the case. Accordingly, case was listed in 2023. Thereafter, Lordship will come. Order dated 9/7/2022. Matters admitted. Let copy be filed by 9 September 2022. Rejoinder, if any, by 23rd September 2022. Now, Lordship, the last order, even the order dated 19/12/2022, the Learned Council appearing for the state respondents has earnestly prayed for time to file reply. This is a hurdle I have to overcome. Not a single hearing, effective hearing since 2022. So here, Lordship, I draw your Lordship's attention that what would be the fate of this. Lordship, even the order, kindly come to the order dated 6/2/2025. The matter is taken up by the single bench pursuant to the order contained in the notification number such and such dated 23rd November 2022 issued in exercise of the powers conferred under Section 5(6) of the Administrative Tribunal Act 1985. On consent of the Learned Counsel for the contesting parties, the case is taken up for consideration sitting singly. Even I attempted that. Mr. G.P. Banerjee, Learned Counsel, as well as Mr. M.N. Roy, Learned Counsel, appearing for the applicant and the state respondents respectively, have opined that in this matter various points of law are involved. It would be appropriate if it is heard by a bench comprising of 2 members, judicial and administrative. In view of the above submission, let the matter be placed before the bench comprising 2 members. So, Lordship, everywhere I am entering into the traps. Sometime by the states, sometime by because of the reason that there is no member. By the time tribunal will be able to adjudicate this matter, I will be eligible for retirement. So I'm really prejudiced by this pendants, my lord. And factually also, Lordship, this case has some uniqueness, may not be now adjudicated by the Honorable High Court, but before the tribunal got to adjudicate many things, including the question of malafide on the part of the employer. If your Lordship kindly come to page number 30, Lordship will find that in 9/8/2021, where they passed the order as per the direction of the Honorable Tribunal itself. Lordship, here they said that the personal verification, it came to our knowledge that no vigilance. They said that there was a vigilance, and later on, by way of RTI, we were informed that no vigilance action was taken on that day. In the last occasion, Lordship, on the last occasion, I have drawn your Lordship's attention to those decisions. This is before your Lordship, for your Lordship's kind consideration, Lordship, I have nowhere to go.
There is a vigilance case pending against you.
No. That is factually incorrect. That's why Lordship, I said that it's unique. They said that there is a vigilance case. Then I filed RTI. They informed there is no vigilance case. Vigilance informed me.
That is what the order says at page 34.
Yes, this 34 is contradicted directly by a document. That's the information given by RTI. Go to page. Page 34. This was rejected, but here this information is contradicted by RTI. Lordship, in that other writ petition, I have annexed that document. That your Lordship had the occasion to consider that. The vigilance says that there is no vigilance case against me. It's a premeditated one. They were trying to deprive me on the basis of certain. Lordship, kindly see the conduct in page 49, 39, 30. Since no such documents were received in respect of the applicant from the Cooperation Department, and to expedite the matter, further Secretary Finance Department, wide DO number such and such dated 22/7/2019, requested Additional Chief Secretary Cooperation Department to forward personal verification roll, medical examination report and integrity certificate of the applicant to Finance Department at an early date, but no reply was received from the Cooperation Department in this regard. As a result, this department could not verify the antecedents and other relevant particulars of the applicant, and appointment matter was not processed further. Meanwhile, the applicant moved to the State Administrative Tribunal, West Bengal, seeking direction on the state respondents to promote him.
You said that in response to a query made under RTI, they have said that there
Yes,
is
ma'am.
no vigilance case pending. Where is that response?
So my lord, that document is in, kindly come to page 30, 35.
Please read where it says no vigilance case is pending.
My lord, it's a meanwhile, with reference to the commission letter, number such and such dated 2/9/2019, on the subject noted above, state that no reply to the same has been received till date, though 2 years have since been elapsed. In this connection, it may be noted that contrary to the claim as made by the Wide Cooperation Department, no advice on the commission appears to have been sought till date by the authorities of the corporation. There,
Does not say that there is no vigilance case pending.
they should have written it, Lordship.
Don't say no that it says no vigilance case is pending. You can't make submissions like this.
Lordship, kindly consider this.
Please, this is not appreciated. Therefore, we asked you to read. When you say that there is a information which says no vigilance case is pending, we would like to rely on such statement without having to verify it through the document.
Meanwhile,
So if you are instructed, at least for yourself, be sure of what you are submitting.
yes,
Because you are an officer of the court
my lord,
and we expect you to say things which are born from the record.
I should refer. Lordship is my.
Yes.
But meanwhile, the aforementioned officer has filed an RTA application.
So they have not sought any clearance. That is what it says. It does not say that no vigilance is pending.
Yes, my lord. I stand
Yes.
corrected on this.
And they have not filed. Who is appearing for the state? You are appearing. You said that reply was filed the other.
My lord, the respondents therein, my lord, in terms of the way it was written, my lord, the principal secretary, my lord, the director of cooperative body, director of cooperative and public service commission. Now, normally, my lord, the state respondent means, my lord, on behalf of the secretary finance department, state of West Bengal. And the director of cooperative, my lord, under which, my lord, the unit under the serving state as a coordinator. Now, the director of cooperative body and deputy director of cooperative body, my lord, they are being, my lord, represented by this. Since here also, my lord, it is appearing.
For cooperative, he is appearing.
I cooperative 8 lordship, Lord. Now, respond number 3 and 4. I have tried my little to ascertain that what the number is not being filed. But let's say that not in some form. Now, the only thing I can do.
You are for 3 and 4.
But I appear for 3 and 4.
And you are for 1. 1 and 2. And who is for 5? Have you served on 5?
Page number 20. Malak, it is mentioned there as a factor for 1.
Whether it is served or not.
Yes, that we have seen.
Dealing with those facts, we don't, but the matter is very short, can be dealt with their should have been filed by this guy. Should be there, my lord can direct them, responding to whoever. Find their within a very short period. Maximum 3 weeks.
No, but one of the respondents is not here. He is not served. But they, how an order can be passed behind their back? Why you are not served, sir?
Well, whether way is served or not, I have to verify.
No, we are not talking about OA must have been served. We don't know. It has been taken up on so many dates. You are saying it has been admitted also.
They have not appeared, Lordship. On behalf of the state, Lordship, kindly come to order dated 19/7/2022. It says that
I appear for state, but the thing is
Mr.
that
appearing on behalf of the state respondents. And one of the state respondents appeared there, Mr. M.N. Roy.
Yes. The short grievance of the learned
asked for, give me an instruction, number 1. It was represented by state. Till date, nobody asked for it.
So how is he at fault?
Now,
Put your house in order. Why are you telling us? Put your house in order. Ask them why they have not asked you for instruction. He is representing you. He is not representing anyone else. Yes, her learned advocate for the writ petitioner.
I have to again come back. You see, chairman doesn't come. Grateful, my lord.
My lord, we have the liberty also to file it.
You
Respondents.
don't listen to us.
Grateful.
Item number 2. My lord, I appeal for the petition.
I have a statement, sir. Yes.
My lord, I appeal for the petition.
Yes.
My lord, for the purpose of recapitulation, my lord.
We can proceed.
My lord, I'm sorry. My lord, I succumb to the helplessness, my lord, because my lord, every day, my lord, my lord, for the purpose of recapitulation, my lord, the post of drug inspector, my lord, was notified.
What is applied for the post?
I applied for the post.
The post of drug inspector.
Yes.
What is the date of advertisement? Give us
9/10/2018, page 37.
making is the advertisement. When the result was declared?
8th March 2019, I was shortlisted and called for the document verification cum interview on 13th March. 8th March,
And 13th was supposed to appear for the verification.
verification cum interview. Once the verification is complete in all respect, I was supposed to call at the interview board, and accordingly this was done.
Same date.
Same date.
What happened? Your verification?
No, now, my lord, before that, 3 posts, 2 for general, 1 for scheduled caste.
What happened on 13/5/13?
I appeared in the interview board, before the interview board. Now, my lord, then July 2019, a notice was issued by the Joint Secretary, the concerned department, for appointment to the post of the inspector, my lord, and my lord, where I found, my lord, that my name was not there.
The select list was published.
Yes. Now, my lord, my case is threefold. I have 3 submissions to make. I wanted a disclosure of marks, cut-off marks. I said, my lord,
So after the select list on 10/7/19, when you realized that you had not been selected, what did you do?
my lord, I filed this way, my lord. The tribunal had made out a third-party case. I made a representation on 16/3/2021.
No, this is of 21. OA.
Yes,
The select list of July 19.
19. During COVID, my lord, there was, my lord, omnibus, my lord, relaxation, my lord, is are available, my lords.
19.
So today, my lord, page 55, my lord, the representation. If I may take,
Yes. Relaxation in 19.
20 to 2021.
20 years. Anyway, yes.
And the tribunal limitation, my lord, your lordship knows, my lord, that I am well within the limitation.
Yes.
Tribunal, my lord, believed the state government, the secretary. They said, my lord, I did not, my lord, submit the requisite qualification to that experience certificate. Experience certificate carries 10 marks. It is not a mandatory. Had it been a case, assuming not admitting that I did not submit, my lord, this essential qualification, although I have, then, my lord, I was not entitled to get 10 marks. 5 marks. Sorry, my lord. Where is the evidence, my lord, that the 5 marks is allotted? Page 40 of your lordship's brief. Rule to them. My lords got it?
Yes.
Now, my lord, 4th column, professional experience per year marks, 5 marks maximum.
In this case, what is that experience?
In this case, my lord, yesterday I had shown page 87 of your lordship's brief. 87.
No, what is the requirement as per the advertisement? Experience of manufacturing medicine.
Yes.
Training in manufacturing medicine.
A degree in pharmacy, and
and specialization such and such from a university and shall have undergone practical training in the manufacture of Ayurvedic or Unani drugs, as the case may be, or that is
Where is that? Which page?
page 87. Experience certificate.
No, where is the requirement? The advertisement, relevant portion
Page
of.
37. Essential.
Yes.
training.
Training in manufacture of Ayurvedic, including Siddha or Unani.
Or
drugs.
Unani.
This doesn't say about experience. This says about practical training.
Practical training, Millard, that is, it indicates in a way, Millard, the underlying meaning. And
Yes.
page 89, Millard.
So this is what, according to them, you have not submitted.
According to them, that's admitted. Now, Millard, I relied on a rule, 1965 rule. When this rule, Millard, the court intended to rely, then, Millard, the court was confronted with a submission made by the state that look that these rules have changed. Now, what is the rule, Millard, 1965, which I was talking about? That is 3rd December 1965 rule. Kindly comes to page 4 thereof. It was with your lordships. I am relying on, Millard, clause 4, Roman 4, clause B. Qualifications for a direct recruitment. A degree in pharmacy or pharmaceutical chemistry, or postgraduate degree in chemistry with pharmaceutics as a special subject of a recognized university, or a diploma in pharmaceutical chemistry granted by the Pharmaceutical Society of Great Britain, or a degree in medicine or science of a university recognized for the purpose of having at least 1 year postgraduate training in a laboratory, such and such, Millard. So, Millard, there is no requirement. If your lordships look into, Millard, the scheme of the rule, the rules do not speak about any requirement. It does not even whisper. So, Millard, if that is the case, Millard, this is not the case. And, Millard, my respectful submission before your lordship, every court or tribunal is required to adjudicate the dispute where the legal issues have been raised. The tribunal, it was incumbent upon the tribunal, that is my humble understanding, subject to what my lords will say, the tribunal was duty bound to adjudicate the issues raised before it. Unfortunately, Millard, tribunal, Millard, omitted, and, Millard, it turned a Nelson's eye, Millard, to these particular issues, Millard, issue raised before it. So, Millard, I request your lordships, Millard, to look into, Millard, the reasons weighed with the tribunal, Millard. And this
advertisement is issued in 18. You are relying upon a 65 rule.
Yes, that is the rule in vogue. And, Millard, the authority, they have not shown any other rule. It was incumbent on the state to show that the rules which I have relied on, that, Millard, rules have gone into oblivion.
That is one aspect of the matter.
No, Millard, second aspect, the rules that were given to your lordship. Millard, kindly, it's a notification of 2012. Millard, my understanding of this notification, if your lordships look into this, Millard, it states the existing recruitment rules for paragraph C1. If your lordships, Millard, look into the notification C1, it states the existing recruitment rules for each category of the post will remain valid, mutatis mutandis, until further orders, and the West Bengal Health Recruitment Board will select candidates as per these recruitment rules. Such provision, Millard, makes it clear that this notification does not effectuate any change. Because it was, Millard, it says only that, Millard, that certain services, Millard, had been dealing from the purview of the PSC.
But you did not raise any issue regarding the requirement in the advertisement.
My lord?
When that requirement was incorporated in the advertisement.
Because it was never the issue, Millard. I did not get the minds of the authority as to why my candidature was rejected.
That's not the point. You knew you were required to submit this.
No, Millard, I have submitted. I have submitted. Your lordships kindly have the charity to believe, Millard, my client's contention. They did not file any affidavit.
They are not asking you that.
I am saying
there is
that
an advertisement.
I said I submitted.
There is an advertisement which requires you to submit a.
I have submitted.
Practical training experience.
I have submitted.
You apply with open eyes, knowing that this is a requirement.
This question could have been
now, can you say that requirement was?
Did I say anything? I said, Millard, I have submitted. I said for the argument's sake.
So that is the issue. that you have submitted?
I have twofold. Yesterday, your lordships was minded to address the issue and possibly, if I have correctly understood the minds of the court, that why the 3 posts.
No, that all that will come later. First is
First thing I have submitted.
First thing is you have applied. You know the parameters which you are required to fulfill.
Yes.
Whether you have fulfilled that parameter or that is the basic issue.
Right.
Only thereafter any other issue will come.
I
So let us see.
I submitted. That is my averment and that is my page 91, 87, 87.
Page 91.
87. I have shown 87 onwards.
No.
I have given
87 is a copy. We don't know whether you have submitted or not.
Millard, I have shown Millard at the best of my ability. I could not communicate myself.
No.
Millard,
Where is the OA? What have you said in the OA regarding submission of this practical training certificate?
This issue was never raised. I could not, Millard.
There is no question of raising the issue. That's a requirement in the advertisement.
I could not foresee, Millard, anticipate that what would be the submission of the state. I said why I were not selected, why the what is the cut-off marks, and why the entire posts were converted to reserve category. The moment, Millard, they confronted, they said these issues are not germane. You did not submit. I said I submitted because I have shown your lordship the parameters of this.
So it is only when they file a reply that you realize.
Not reply, only written instruction.
So whatever their response in whatever way they have filed.
They respond. I was not given any opportunity to contradict, to controvert.
Yes.
So your lordships many a times at least
how do you say you are not given opportunity to controvert?
Because the order says.
Let us see.
Or let us see read the order.
Yes.
I am extremely grateful. Order ta padao. Yesterday. No. Order ta padao. Don't make a fragmented submission. Sorry. May I read for my lords? From the third paragraph. From the record and submission of Mr. Bhattacharjee, learned counsel for the applicant, it is understood the applicant had participated in the selection process for the post of drug conducted by the West Bengal Health Recruitment Board in the year such and such. Out of 3 posts, 2 posts for UR, 1 post for SC category were reserved. The applicant belongs to unreserved category. After the conclusion of the process, 3 candidates were recommended as per the category mentioned above, but the name of the applicant did not feature in the list. Submission of Mr. Bhattacharjee is that though the board displayed the names of the 3 candidates being recommended, but such notice did not give the breakup of marks obtained by these recommended candidates. Similarly, the board did not publish the breakup of marks of any candidates who had participated in the interview. By not displaying the revealing marks, the board concluded the entire selection process lacking transparency. In response to the statement made by Mr. Bhattacharjee, Mr. Banerjee, learned counsel had submitted that though this advertisement was published in 2018, the entire selection process completed by 26 July 2019. This applicant filed this application before this tribunal in 2021. Therefore, it is barred by limitation. Mr. Banerjee also argued that though Mr. Bhattacharjee had used the words lack of transparency in the entire selection process, but nowhere in the application such a deficiency on the part of the board has been stated. Besides the above point, the board could not recommend the name of the applicant for the primary reason that he did not possess or presented a certificate of his having completed a practical training in the manufacture of Ayurvedic drugs as stipulated in the advertisement. Responding to this point of limitation raised by Mr. Banerjee, Mr. Bhattacharjee argued that final list of recommended was published by the board only on 26/7.
What is the date of the statement signed by the secretary which has been filed?
That is Millard with them. Were submitted to the tribunal.
Your Lordship, this is a part of the affidavit in
No.
opposition.
Oh, this is the one. Statement means affidavit.
Your Lordship, page 50.
Last page of the impugned order says that there is a statement signed by the secretary saying.
Yes. Oh, sorry.
Your Lordship, this has been
16, page 16.
What is the date?
16.
This is your Lordship.
I.
Lordship 2022.
No, that I will not.
And that is not legible, Your Lordship. The sign has been.
Which page?
Page 16.
Page 16 of the opposition, Your Lordship.
16.
Opposition.
Yes, Your Lordship, I have annexed the statement, Your Lordship, starting from page 15.
Date is at page 16.
The file number is dated 2021.
So on the basis of this statement only, the tribunal has disposed of
Yes.
the OA. No opposition, no reply, no opportunity.
Your Lordship, even in that case, Your Lordship, the opposition was filed before Your Lordship. The reply has been given by my learned friend in this, before this court. Even in the reply, there is no iota of evidence that they have produced, that they had submitted. Your Lordship, let them produce a scrap of paper that shows that they have produced. Your Lordship, may I come to the advertisement? Lordship, kindly comes to page 37 onwards. The advertisement dated 2018. Your Lordship, the third paragraph, a candidate would verify from the notification that he or she is eligible. The condition prescribed cannot be relaxed. The recruitment shall be made by.
No, we are only on the whether the order of the
one-
tribunal is sustainable or not. If not,
Your
it
Lordship,
has to
Only
be-
one in the subject to correction. Your lordship was taken to this paragraph, which at page 2.
Your Lordship, page
Uh,
42
if-
doesn't indicate that your.
You will be allowed to,
You
just a minute, madam, I may be wrong. You will be allowed to appear at the interview on the same day. If all the candidates are authentic and West Bengal is satisfied that you fulfill the laid down qualification as mentioned in the advertisement, the date and time. So it is presumed. There is no other conclusion to be arrived at.
So then what is the verification process?
On the days I entered, they verified, they allowed me, they satisfied. Kindly see, with reference to our advertisement for recruitment to the post of inspector under health and such, you are being called for documents verification. Page 42. There is no ambiguity. Kindly see, page 42, my lords. Very specific and clear. With reference to our advertisement, may I read for my lords? With reference to our advertisement dated 17/9/2018 for recruitment to the post of inspector of drugs, such and such, you are being called for documents verification. You will be allowed to appear at the interview on the same day. If all the certificates are authentic and West Bengal Recruitment Board is satisfied that you fulfill laid down qualifications conditions mentioned in the advertisement for the applied post, the date and time and place as follows. For your lordship's consideration, it is nobody's case that I did not appear in the interview board. There is no evidence.
But this does not show that you have submitted. There is acceptance.
Verification, my lord. Kindly, there cannot be any other meaning, my lord, subject to correction.
Otherwise, then that exercise would not be required.
My lord, 22
exercise on 13.3 would not be required.
13.3.
13.3 exercise would not be required.
No, but question is, my lord,
everything was in order, then if they had accepted everything to be in order, where was the question of having a verification?
One date of interview, one date of verification. I was called.
So at the venue, they check whether everything is in order and then they allow you.
Yes, allow.
They say it was not there. That is a specific standard.
That stand after 2 years, my lord. That is, how can I?
Whenever you ask, then only
No,
they
then
will tell
question
you.
is, my lord. Question is, my lord. If this is, my lord, if this condition.
There cannot be no presumption from this document that you have submitted a training
I
certificate.
put this question to myself. Is there any other way of looking at the matter, my lord? That this is, my lord.
The only way of looking at it is they are asking you to come for a verification. They want to see whether all the
if they are
testimonials.
satisfied, if that is the conditions,
Yes.
that is why I was allowed.
Does it say that
But
those
it
who
was-
have not submitted
But it is not.
those who have not
I am
submitted,
extremely grateful.
those who have not submitted the practical training, they will not be called for
No,
verification?
I do not know. But
Is
the
there
question
any
here is,
exclusion in the process which is laid down in the advertisement? Does it say that only those who are found to have submitted all the requisites,
in a
they
way,
will go for the document verification?
yes, because if
Just show where it says.
it will be allowed to appear. That means the condition.
Please show where it says in the advertisement that only those who have submitted all the requisite
I am extremely
documents.
grateful. Kindly seize the meaning of this English. You will be allowed to appear.
From which page you are reading?
I am 42. I am emphasis.
No, come to the advertisement. Where is the procedure that only after all the documents are submitted, you will be
These
allowed to
documents
go for
verification come interview later. It stipulates.
Sir, that has nothing to do with the procedure. You are now saying that there is a procedure that only if everything is submitted, then I will be called for verification.
That is what this indicates.
This cannot indicate. If that is a procedure, that has to be laid down in the advertisement. It cannot be.
Whether your lordship can.
This cannot be introduced after the advertisement. It would have been there in the advertisement that only those who have submitted the documents, they will be allowed to come for verification.
My lord, the advertisement.
It cannot come at a later stage.
My lord, kindly sees, but the tribunal, the manner in which.
So therefore, that has to be considered.
And my lord, the conversion of the entire post.
We don't know. All that issue will be considered by them.
The tribunal did not address this issue.
They have to consider.
But the tribunal is not functioning.
It will not remain like this forever. It will not remain like this forever.
But the government has maintained angelic silence for the last so many years. Only one man was running the show.
That we are aware, because at least for 1.5
years
now,
even the high courts have made an endeavor. Even then, my lord, it has fell into the deep.
So Mr. Mukherjee was telling us few days back that perhaps it is in the process very soon. It is being done.
The state of West Bengal, my lord, your lordships cannot make any comment. Sitting, my lord, Justice Dotto, when his lordship was there, also made, Justice Tandon also, my lord, made a comment. My lord, the government, my lord, the moment, my lord, we are, my lord, a system without a judge, my lord, the consequence always goes in favor of the government, my lord. At least this is a check and balance in a democracy.
He was saying that he did not want to put anything on record.
Mr. Mukherjee, with the deepest respect, my lord, Mr. Mukherjee has taken a very consistent lenience stand whenever, my lord, the court has asked any problem, my lord. With his inherent generosity, he has said the government is looking into the matter.
No, he did not say that.
He said because it is for the persons who would take the decision. Now, my lord, the entire climate, my lord, the tribunal, my lord, pathetic condition. Pathetic condition. Since the bar is silent, my lord, on the issue, my lord, since we are not representing many a times a collective interest, my lord, it is not for us, my lord, to speak, my lord, the bitter truth against the system, because we need to earn daily, my lord, which makes us coward. We don't offend to the men in power because we are guided by a stomach-oriented philosophy. That is the whole difficulty for our part. The tribunal, the way it is functioned, my lord, it's just like my lord, the silence, my lord, all pervasive like a burning hut or a graveyard. People are roaming here and there. And
no, the office has been vacated in September.
One judge, my lord, one man show. The judge took, my lord, 1 year time, 6 months time, my lord, to pass an interim order by the interim order. Who will tell this truth to your lordship? Your lordship cannot have any personal knowledge. We are spineless, that is why we are silence. We maintain silence because we don't want that the institution should flourish. But your lordships many a times have taught us that public common litigants are the stakeholder of this institution. We are not. But I do not know. I will call Mr. Mukherjee, my lord.
Yes, he was. Where is he?
Better your lordship talk to the Advocate General. That is my humble suggestion.
Where is Mr. Ask for Mr. Mukherjee to come?
Phone call. Phone channel.
He was saying that.
Your Lordship, if I may be allowed to make one submission, Your Lordship, the challenge that has been thrown in the OA, Your Lordship, entirely depends on the fact that if at all the petitioner has a locus or is eligible to be to challenge, if he is not even eligible, his application is rejected. Your Lordship, a candidate challenges the appointment of a particular person in an ST category is understandable, where I am getting a higher score, but the SC or ST person has been appointed, my appointment has been affected. In this case, Your Lordship, the petitioner is not even eligible. As on the date of application, he has not submitted. His application is incomplete. How can he challenge an appointment of a third person? Your Lordship, a candidate who has scored higher than the highest scoring regular candidate. He is not even eligible to challenge. And after participating, after being rejected, after not qualifying, he comes back and indicates regulation 65 and challenges the advertisement itself.
He is not challenging the advertisement.
Your Lordship, before
the panel.
Panel, Your Lordship.
He never challenged the advertisement.
Your Lordship, the clause section 60, regulation 65 was never placed before the.
Therefore, it was required to be considered. It has to be considered. Whether you can rely on that now to challenge the advertisement or not, that's a different issue. But there has to be a decision on this aspect. Whether it is that he is not entitled or whether it is that
The list was published on 26 July 2019, Your Lordship. His first representation is in 2021.
that was good.
Sitting idle.
Yes, you were saying that there is some step is being taken for filling up the vacancy of the tribunal.
Everything is complete now. When I say, when I find it, His Excellency, I will lie with His Excellency.
Can you give us some expected timeline?
Because after the Excellency's approval, it will go to the Her Excellency under the new act. But that was forwarded in letter of 15th or 16th October.
But there must be some expected timeline, another week, 2 weeks, 3 weeks, something. Huh?
Retired judge of the Tamil court. Retired judge of
That's not the point. We are asking you what is the expected timeline?
by expected by end of December. This month.
End of business.
Any date. Any date. Yeah, any date.
Kirat Patale, season is
Don't want to go back.
My lord, sorry, my lord.
Don't want to go back to the tribunal.
No, if my learned senior friends, my lord, information is correct, then, my lord, I don't mind, my lord, to December, because your lordships.
I cannot say which date His Excellency.
That is why I was requesting my lords to also take assistance from the learned Honorable Advocate General, learned Advocate General, so that he must be armed with better.
May I just interrupt one thing, my lord? One matter has been filed with regard to this aspect, and I am appearing for the state in that matter, my lord. And so far the tribunal's issue is concerned, my lord, it was pending initially before the Honorable Governor, and now recently, my lord, we have taken a note from the, my lord, the Governor, and we are under process to appoint the, my lord, the chairperson and before the tribunal, my lord. The consent from the Honorable, my lord, His Excellency, the Governor has been given just a week ago, my lord.
Oh.
So, my lord, it is under process, my lord. This much I can say before His Lordship.
So, just a minute. ঠিক আছে, the tribunal decide করবে. All issues are left open.
Yes.
And, my lord, in the event, my lord, in the event, my lord, I request your lordship, my lord, keep it pending, my lord. That is why I was requesting.
What is this?
My lord, if it is
Neither legally neither legality demands nor propriety demands.
legality doesn't.
Yes, heard learned advocate
But I'll be grateful if Lordship taken up this matter next week, this item number 3, because I am not well for not being in court, my lord, and it is cannot be done virtually, my lord. Affidavit has been exchanged, all these pleadings are completed.
He's in Belur. He's in Belur.
No, I am not in Belur, my lord. I am in
surrounded by Swami Sarvapriyananda, all Millard monks and saints. That is why he doesn't want to come.
No, my lord. I am at my house, my lord. I am suffering from a back pain. That is the whole problem.
No, he's going to the path of renunciation.
No.
How much time you want?
Well, next Monday, Lordship will take up.
Next Monday means date.
Keep.
Any day. Next week, any day, my lord.
Yes, Mr. Basu, you.
Subject to convenience of Mr. Basu, my lord. He is more
Yes,
important
we need
person,
to
my
have
lord.
his convenience.
Yes, my lord.
It will be audacity.
We have learned yesterday.
No. And I apologize, sir. It is your lordship only, Millard. Normally, Millard, I have the audacity. I should say, Millard, at least Millard indulgence, Millard. There are few courts, Millard. Otherwise, Millard, I am not recognized by any other bench, Millard. If I take adjournment, nobody will grant. Nine.
Lordship.
19.
As jointly prayed, list on 19th.
18th. I'm sorry, Millard.
Let it be 19th. 19th or any day thereafter.
18th.
19th or any day thereafter.
Oh, then Millard, 20.
All right. 20, Mr. Malik.
Yes, Lordship.
I am deeply obliged.
Grateful, my lord.
As jointly prayed, list on 20.
I'm extremely grateful, Millard.
Yes.
Item number 4.
My lord, item number 4, my lord, I am appearing for the resolution number 6, my lord.
Yes. Accountant General.
Yes, my lord. My lord, the relief has been, those have been sought for by the.
Yes. What are you saying?
My lord, the relief sought for by the petitioner, my lord, is all with the state employees. My client has nothing to do with this, my lord.
You don't have proper net connection. We are unable to understand what you are saying.
Yes, my
Your
lord,
voice
that's
is
the problem, my
breaking.
lord, I'm facing.
So
My lord,
unless
the relief sought
you
for
want
by
to
the
make any
petitioner, my lord, is.
Yes. Paper book. Have you filed the paper?
Yes.
When?
Filed the paper. Yes.
And you have filed?
department note আছে কি?
Yes,
One of-
but filed it, filed on 26th August 2025.
26 August.
26th August 2020.
Oh, আসবে না, department পাঠায়। Cannot be good.
You have filed it in the department. There is no noting here in the file. Where is there is any kind of receipt given for filing endorsement? Let us see. It is recorded by you, but nothing.
We have served the copies upon the response. We can verify it, but they can.
And then
We can.
by the judiciary verify. It was filed.
It was filed.
The department does not receipt. So
No, but it would have been recorded in the order sheet. It is normally entered. Filing of paper books is recorded. There is no note. Yeah.
Contact person, our end, we will verify.
Advocate for the writ petitioner that you say it we have filed, it must have been filed. Let us see. After that, the week after.
হ্যাঁ 26 ফাইল হয়ে গেছে
ঠিক আছে এখানে এখন তো
বুঝে গেছি আইটেম নাম্বার 5
Every day today's accommodation. Today again a prayer is made for accommodation.
item number 6
this is my appeal. Better.
You have served on the learned DP.
সরকারকে দিন তো সব চাই
Your Lordship, that I have another. He asked you to serve on the GP by hand. There is a by hand. That has been done, my lord. You have served on AGP. Why on AGP? You have served on the additional government leader, not on the government leader. Why? Your Lordship, take it day after tomorrow. I will intimate it. Because my landed, my advocate on record this site not checked up. It's not a he. After all, he is also advocate. The order is clear in what we say. Whether it is you or the advocate on record, this is not expected. Who has to appear? Who is this case? Nobody is appearing for the state. I will start the copy and take up tomorrow. No, that way it cannot be done. He will have to take instruction also. And be like, should we appoint? You serve on the GP first. You just serve, then we'll see. The Monday week. Two piece. এটা সাজেস্ট করতে বলছো
Seven minute. I am for the state lordship in this matter, my lord.
Application number 6.
Item number 7.
But kindly tell Mr. Islam to use the microphone, my lord. Use the micro. I cannot hear you.
Learned tribunal rejected my claim of retirement dues on the ground on non-refund of the CPF amount. My lord, that is challenged in this writ petition. My lord, in nutshell, my lord, I should place the facts. 75, this petitioner was appointed as Toshildar, husband of the petitioner. My lord, government decided by notification to regularize their service in a post of Bhumi Sahayok. My lord, they have been allowed to be the Bhumi Sahayok.
With effect from
1984. 1987, I was not allowed to function as Bhumi Sahayok without assigning any reason.
So they stopped taking work.
Yes, but my qualifying service from 75 to 87, that is 12 years. I approached this tribunal earlier.
From 75 to 87. How
Sir.
can it be? You have come in the regular establishment in 84 only.
84, but that continuation has been granted.
In 84?
Yes.
Where is that 84 document?
Yes. Continuation memo. Page 48. Page 44, Your Lordship kindly sees.
Your husband's name was Abdul Momin Mandal.
Yes. Page 44, counting of the past service of Toshildar towards calculation of pension and other retirement benefits to the Bhumi Sahib. By this memo, the Toshildar's service has been counted as the regular service.
44 is your representation.
No, 53. 44 in এটা কাটুনি কেন?
No, this is of 95. We are saying the regularization order. Does the regularization stroke or absorption, whatever it is, does it say that the past service are to be counted?
Yes, কোথায় ওটা কত?
When in 84 they have absorbed it.
এটা 95 এর মেমো। আমার রেগুলারাইজেশনের মেমো কোথায়? Yes, page 35 is that memo where the continuation কথা বলা আছে।
Yes. So there is nothing in this regarding counting of
This is regarding
service under the Tehsildar.
yes, absolutely. Absorption is only there. That counting of service came into effect in 1995.
95.
Since there were some clarification was required, some of the candidates are being retired. That's why this clarification memo came. রিপোর্ট দিয়েছিল সেইটা কত পাতায় সেটা কি বলতে পারবে? হ্যাঁ সে বিএলআর রিপোর্টটা কোথায়? 40, yes. Yes. Now, at the time of
So at the time of issuance of this decision
Lordship,
by this memorandum, you were in service.
I was in service.
But you said they stopped taking work from you after 87.
87, but without any reason. Only I have been debarred to functioning of the.
They have issued any order in this?
No,
way?
nothing. No show
They were
cause,
not
no
taking.
discipline.
They were not taking work, and you were not working, and nothing was being done. You also sat over the matter.
My lord, I went to the office. My lord, this work is for collecting the taxes from houses door to door. My copies of receipt and the ledger book was taken away by the officer. I wanted to return of those documents so that I can collect the taxes. My lord, they, on the assurance they will do this, they will do this, that has not been done. And I approached the tribunal for resumption of my duty.
Where is that? That's what we are asking you.
Oh Lord.
What steps did you take when you were being prevented from working?
Tribunal এটা দেখাও, ফার্স্ট ট্রাইব্যুনাল অর্ডারটা দেখাও। Page 50. Page 50.
Page
50.
So these are not the issues. The only issue is that you have not surrendered your CPF amount.
Yes. My lord, while I was not allowed this, my lord, way as at page 50, that was dismissed because by this time I retired from service.
What was the relief claimed in this OA 1386?
For resumption of service. Since I was not allowed, that was
It could not have been because you retired in 2009. How could you make a claim for resumption in 2010?
No.
That could not have been the relief there because you were.
I retired 2012.
No, sir. It records that you attained the age of superannuation in 2009. Therefore, in an OA filed in 2010, you could not have claimed a resumption of duty. At best, you could have claimed some post-retirement dues. And this is an admitted position recorded in the order.
My retirement is of 2012.
Please read page 51.
51. But thereafter, only in 2009, he made an application for resumption of duty.
Yes.
There is no, this is not the date of retirement.
Now, please read.
There is no reasonable explanation coming from the petitioner what prevented him not to approach.
By this time, he has already attained the age of superannuation at the top of page 51. So there was no question of resumption.
By this time, he has already
He has already attained the age
on the day of order. By this time.
So what is your date of superannuation?
2012.
What date?
Date of birth. Because ওর রিপোর্টেই তো বলা আছে 28th of February 2012 ওদের রিপোর্টটা কোথায়?
Yes.
and challenging this order, since there was no liberty granted for approaching the tribunal for retirement dues, we approached this Honorable High Court, page 55, where this Honorable High Court granted me liberty to approach the tribunal for my retirement dues.
Very well.
My lord, I approached the tribunal, my lord, all alone. Though there is a provision for refund, my lord, what is the quantum amount to be refunded? I asked for them for supplying those data or details that has never been supplied to me. And surprisingly, in my way, 2 ways, they have not disclosed their stand of refund at any point of time, so that I could refund it. Ultimately, the report filed by the PLLRO, pardon? Arts. Reportটা কোথায়? হ্যাঁ। বেশ। আমি কি এটা কত? $55.
So 87 to 2012, you are not claiming anything. You are only claiming from the 75 to 87.
That's true. Only the retirement dues, my qualifying service has to be 10 years. That process, therefore, I am entitled to have my claim of retirement dues. If anything has to be refunded, they have to ascertain me this is the quantum of your CPF, you kindly refund it. I will refund it. That has never been done.
When did you ask them? What was the dues outstanding against you?
In my way also.
Where is that? Show us.
They have not disclosed.
No, where have you asked them for the outstanding with that I want to pay this back to you, refund this to you? Tell me, I don't know what I have received as employer's contribution. You tell me.
That সেটা কি লিখেছিলে তোমার বইয়েতে? আচ্ছা, তোমার ওয়েটা কি করনি, অ্যানেক্স করনি? কোথায় সেটা? ওয়েতে তুমি বলেছো সেটা?
So anything from the OA or any communication that I am unable to refund this amount because I don't know the outstanding, please let me know the outstanding.
ফান্ড করতে চেয়েছো সেইটা এখানে অ্যাবারমেন্ট কোথায় আছে? In the way, there is no such documents. I don't find it.
There's any averment in the OA that?
That is also not there.
Then, sir, neither you can say nor he can say that this was the case of the applicant petition. Unless it is the applicant's case stated in the OA, how can you say? You cannot say. So therefore, then what is the infirmity in the tribunal's order?
I mean, go through. My lord, let me come back. My lord, I shall go through every paper. So yesterday, I have been.
All right. Not today.
Lots.
Make it on next week, my lord. Make it on next week, my lord.
When do you want? Which date?
20th, lordship. Fix another matter on 20th. Let it be on 20th also.
A specific submission
The
has been
candidate
because
Item number 8.
Number 8, my lord, I am for the petition. My lord, on the last occasion, my lord, your lordship, my lord, kindly recollect, my lord, I supply a judgment Jaggo, my lord, passed by the Honorable Justice Bikram Nath, where, my lord, the regularization. Yes, my lord, and Mr. Mukherjee, and a senior advocate appearing for the respondent, he has to submit, my lord.
Who is appearing?
Lordship, 8 and 9 are analogous matter. Lordship, in one of the matters, Mr. Mukherjee is leading us. Just identical matters. He was here.
On the last occasion, my lord, they took time, my lord, on the that after getting the judgment, my lord, I already supplied the judgment.
Let's have it next week. Not here. Another judgment has come after Jago.
Other judgment, na?
You have not seen?
Item number 10.
Mr. Swapun Banerjee is for the petition. The state.
You are for state.
I am for the respondent, appellant for the trial. That is the point of 906.
You are for the writ petitioner. Why are you standing on the respondent side?
So, respondent. Writ petitioner. State is the appellant here.
There is a writ petitioner, there is no appellant. We are asking you whether you are writ petitioner, you are saying yes. You are standing on the respondent side. Yes.
Mr. Swapun Banerjee is appearing, but I am praying for not today.
All right.
Next week, madam.
Not today.
Eleven.
Reply.
Filing affidavit in reply.
Reply. You are filing reply. Delayed payment of gratuity. Delayed payment of what only gratuity. CPO, my lord, is at page 35.
Who is for respond number 2?
Dated 20th of
Who is for respond number 2? Have you served on respond number 2? Sir, we are asking you who is for respond number 2. Have you served on respond number 2? You are pointing to him. Why you are pointing to him? How he will represent respond number 2? Don't ask him. Look at your.
my lord, affidavit of service filed on the other. Send the paper to the or 20.
Where you have served on respond number 2? Show us.
I am very sorry, my lord, that on instruction I have submitted.
Every time we are saying, he's saying yes, 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 nodding his head as if he knows it has been done. And he has not done it. You should be very sorry.
I am extremely sorry.
Let notice be served on respond number 2. And affidavit of service be filed within 2 weeks. File affidavit of service. The reply is being taken on record. Yes.
On instruction I have submitted.
Yes, what can be done?
Item number 12.
The office has returned in 22. Yes, please. Why we are why they are treated, how the state can be held responsible.
Well, this is my lord, matter well yesterday, my lord. Well, there is a state has
There was no reply in the tribunal.
No, well,
Therefore,
this
we
is-
must have allowed time.
well, the point of well, this
Where there is a reply before the tribunal, normally we don't allow time. We go by the records as they are. But since it has been,
well,
you have any instructions?
only one thing, well, in this case, well, this death come retirement benefit rules, well, rule 36. Well, it applies on me first, and second is the order of the tribunal is absolutely in a different, well, on a different score, my lord, without touching the merit of the matter.
So we should decide without any opportunity to the respondents.
Well, probably, my lord, as per my humble submission is considered, my lord. Well, the tribunal has gone into a. Well, this is a, well, what has happened, my lord. A panel was selected in the year 2008.
Therefore, we are asking you, therefore, we should decide without any opportunity of filing opposition.
If they, they have your lordship.
That is the only issue right now. Whether they want to file, they have already taken
They have
time.
chosen not to file for last 2 times.
Second.
Well, if your lordship grants the liberty, well, I don't have any objection.
What is the tribunal's order? Come to the
My
tribunal.
lordship will kindly see the tribunal's order, my lord. That is at page 15, my lord.
Your claim is for?
Well, I am only, my lord, claiming that Rule 36 may be invoked so that when the 6 months service, I am within the 6 month service period. So, well, I am not getting the pension. But the calculation has been given a wrong.
What is your qualifying period according to them?
Yes.
Not according to you.
Well, I have completed 10 years.
What is
6
the
months
qualifying period according to them?
10 years, minimum 10 years.
What is the qualifying
They
period?
are saying that I am beyond 6 months. 9 point
Less by 6 months.
less by
So according to them, you are 9 years and
9 years and, my lord, 5 months or so, 17 days as per their calculation.
5 months and 17 days.
Now, my lord,
So more than 6 months.
no, in my calculation, my lord,
First, we ask you according to them. You are more than 6 months.
kindly
According
records the date. Then, my lord, I should be very specific on the date.
must be, has to be. Otherwise, it cannot be considered.
Yes. Lordship will kindly takes page 34. That is my appointment letter. That is at page, my lord, that is date. Appointment was given on 27th August 2014.
Page
34. The page 34, my lord, Lordship will kindly see.
So when did you join?
This is the joining letter, my lord.
This is not the joining letter. This is the appointment letter.
Yes, my lord. Because my lordship will kindly takes, my lord, what has happened. Joining letter, no. My lordship will kindly take.
This cannot be the date from which your service will be counted. Your service will be counted from the date of joining.
Yes, my lord. Well, I have in that case, my lord, this is the office order, my lord, at page 36.
12/9/14 you have joined.
Yes.
You have joined on 12/9/14 according to this document.
12 September.
Yes, 12/9/14.
Now, my lord, 12 September, my lord, and my lord, will kindly takes at page 37. That is my retirement date is at
29 to 24.
Yes. Now, in this case, now the tribunal has gone in a different as in respect to a judgment of Supreme Court, wherein in this case, the panel was selected in the year 2008. Subsequently, the panel was challenged. It went before the Supreme Court, and ultimately Supreme Court has sustained the panel. That is at that the order is at page. It starts from. It starts from page 21.
So it is more than 6 months.
Now, my lord, but I am on Malad.
So how you can get the benefit of 36 if it is more than 6 months? Just let us come to that is the only point.
Malad, Lordship will kindly
Let us see
take, my lord.
DCRB.
Yes, Malad, I have the rules, my lord. That is, if your Lordship has it, my lord. The rule 4, the relaxation provision is given, my lord. If your Lordship also takes, my lord. DCRB.
So 36 does not contemplate condonation beyond 6 months.
But, my lord, it has to be read with, my lord, rule 4, my lord. Relaxation, my lord. Nothing in this rule shall be construed to limit or abridge the power of the governor to dispenses with or relax the requirement of any of these rules to such extent.
So you have applied to the governor.
My lord, I have, what has happened, my lord, in this matter, my lord, I have made a representation. After that, the tribunal on a different score, my lord, he went on the basis of the Supreme Court judgment. He has not considered, he has specifically stated the rule, whether 6 months I can condone or not, that cannot be determined by me. That is the order. Lordship will kindly seize, my lord, the order itself is bad. My lord, Lordship will kindly seize the order once, my lord. So Lordship kindly sees, my lord, page 16, page 17, man.
So what is wrong with the tribunal when it says it cannot condone?
Well, he has given a different reason, not this reason. Lordship will kindly sees, well, page 16 I am reading, my last paragraph. The Honorable Supreme Court had made it clear in its direction the appointee cannot claim any seniority with retrospective effect, as that might create scandal amongst the appointees in other departments at earlier point of time. The Rule 36 of West Bengal Service
This is the relevant paragraph. Yes.
gives a discretionary power
Yes.
to the head of the department for condonation of such shortfall in service up to 6 months.
Yes.
Without considering the views of the Honorable Supreme Court, it is felt that such condonation even of 6 months may create confusion relating to the seniority of the appointees. If by condonation of 6 months the applicants have moved above in seniority list of appointees, it might create unrest among others for being adversely affected. Besides the discretionary power, Rule 36 of West Bengal so and so, if is restricted only to such cases where the delay in issuing the appointment letter was due to the laches on part of the appointing authority. In this case, however, it does not appear that there was any laches on the part of the appointing authority. Therefore, the prayer in this application cannot be considered of having any merit and thus disposed of. So, my lord, the tribunal went on a different way. Why, my lord, I am saying?
Now we are saying that even if we take it, that 6 months can be granted, still you will not get the relief.
Now, my lord, may I submit two things, my lord? This is not a normal case, my lord, wherein, my lord,
We don't know.
yes, why I am saying
That's not for us to examine. Therefore,
because the
there
tribunal has got
are only two options available to you. Either to get a 6-month condonation under 36 or to approach the governor. You have not approached the
No, I
governor.
have not approached the government.
So therefore 4 does not come into play.
So, my lord, that is open.
36.
That is open, my lord. Rule 4, I can, my lord, I placed before your lordship.
Nobody is stopping you.
My lord, today, a man has served for at least 10 years.
Nobody is stopping you.
No. What has happened, my lord, today I am before your lordship, my lord. The point.
But we cannot assume the power of the governor.
My lordship is sitting on the appeal of this tribunal's order.
Therefore, we are saying setting aside of the order will be of no avail. It will be a futile exercise of writ jurisdiction. You will still not get a condemnation because it is beyond 6 months.
What I am on, my lord.
That will be of no avail.
My lord, tribunal, my lord, let this order be set aside, my lord. Well, I can also, my lord, take this point before the tribunal. Whether, my
What
lord,
point?
the point is that, my lord,
When you have not moved the governor, what point you can take?
in respect to our, my lord, appointment letter is concerned, my lord, that comes within the less than 6 months. The appointment letter.
It does not.
Yes, sir.
It does not.
If your lordship kindly takes, my lord.
No, we have got the dates. Don't show us anything. We'll go by the records as they are.
My lord, your lordship, my
Your
lord,
joining is 12/9/14 and your retirement is 29/2/24.
but my lord, I was given an appointment letter. Lordship will kindly seize, my lord. That is on.
We are not concerned with the appointment letter. We are concerned with your joining only.
Joining letter, my lord.
Yes.
But this is a case, my lord, wherein from 2008 I am suffering. But the Supreme Court has.
You may keep arguing all irrelevant things, whether it will help your client.
Well, today, my lord, I am on Rule 4. The lordship will.
So again, we should say whether you have moved the governor or not. The same thing will run in circles.
Lordship will grant me leave
So
on
that we have said already.
Then, well, I have
That
to
is
take
open to
instruction
you.
on that.
What instruction? No instruction is required.
Well, today, my
That is
lord,
a opportunity available in law.
Lordship, my lord, today, if your lordship, my lord, is sitting on this tribunal's judgment, my lord, may I humbly submit, my lord, that this judgment is wrong on the face. Well, it has to be set aside.
So you know the principles of exercising of writ jurisdiction.
I definitely.
Will the writ court exercise a jurisdiction in futility?
Well, lordship will kindly.
Nothing will happen from setting aside this order. You will still not get anything. We are asking you, maybe this is a wrong consideration. Whether you are entitled to condonation or not would be considered only if the condonation was within 6 months. Admittedly, it is beyond 6 months. Therefore, where is the question?
Very well. In that case, my lord, may I come?
And
back
you
to
did
my lord?
not invoke rule 4. Therefore, we are saying
Oh, my
it
lord,
is open to you. You may have invoked
then my
rule 4.
lordship can give me liberty to my lord, approach my lord.
That is why we are saying you have removed the third learned advocate for the writ petitioner.
Thirteen.
13, I have for the state respondent lordship. Kindly, my lord, ask her to allow the microphone. I couldn't hear him, my lord.
Yes, you have filed a supplementary.
Yes, my lord. দাও supplementary গুলো দেবে তো। This is supplementary. And my lord, evidence of
What is the claim in the before the tribunal?
Yes, my lord. Before the my lord, this is the person who is now about 80 years old.
What was the claim before the tribunal? Let us see.
Retirement benefit, and also only, my lord, I have received the GISS and GPA.
Retirement benefits.
Yes, my lord. He has retired, my lord. Your lordship, kindly see the
petition.
He has been dismissed, you are saying he is retired.
That's why. This is the case, my lord.
What this is the case?
My lord, the
Dismissed him
petitioner-
why he retired.
before determine superannuation age, he was suspended and also acquitted. Subsequently, he was
He
acquitted.
has been dismissed.
Dismissed.
He did not retire. There are two different things.
Yes, my
Don't
lord.
say he has retired. He was dismissed.
He was dismissed.
Yes.
That's why, my lord.
Yes.
The
Don't say he has
petition-
retired.
the-
So after dismissal, one is entitled to get pensionary
My lord,
benefit.
my lord, my lord, he is against charge, my lord, under 468 and also 409. And acquittal was the government was complained before the.
Where is the dismissal order?
Dismissal order is, my lord. My lord, dismissal order supplementary evidence.
June 2000 is the dismissal order. Where is it?
14 June, my lord.
2000.
14 June 2000. Yes, my lord. Your lordship, kindly see.
Come to page 66.
Yes. Page 66. Your lordship, kindly see the supplementary video. Supplementary. The affidavit of service. এটা তো আছে এটা তো আছে সাপ্লিমেন্টারি এভিডেভিটে Page 69 সময় দিন সবকটা এটাতে আছে
Yes. So
that thereafter, my lord, he was acquitted. Your lordship, kindly see the page 69. acquittal order is there, my lord. Start is 69 and main order is, my lord, ordering portion is 78.
Did the petitioner challenge this punishment order of 14/6/2000?
Yes, my lord.
Where he has challenged it?
My lord, before the, my lord, beg your pardon?
14/6/2000, he has been dismissed from service.
Yes.
That order, did he file appeal against that order? Did he file appeal against that order?
Original application that was challenged before the, my lord, before the, my lord, yes, WBAT, Administrative Tribunal, and my lord, 24th of April 2002 order was passed and which was dismissed.
Where is that? So that was dismissed.
That was
So
dismissed.
dismissal order has remained intact.
Yes, my lord. My lord, thereafter, my lord,
So how the acquittal will help you in the criminal case?
my lord, because my lord, acquittal was done, my lord. In spite of that, they have made a they have made a notice that he has already acquitted. In spite of that, no action has been taken by the DLLR or
What
they
action was to be taken?
my lord, because he has acquitted.
So
Thereafter,
there is a criminal case and there is a departmental proceeding.
yes, my lord.
Departmental proceeding, you have already been convicted, you have been dismissed. Subsequently, in a criminal proceeding for a different case, you have been acquitted.
No, not that. On that same cause, proceedings, and state has been given the submission before the court, before the district judge, he has made application. And as per FIR of this matter, my lord, as per FIR charge and also the all papers, same cause of action, he has departmental proceedings has been initiated.
So criminal case was for the same allegation.
Yes, my lord.
So
And my lord, thereafter, my lord, not only that, thereafter, my lord, after
what is the date of your superannuation?
superannuation date is, my lord, 31st December 2005.
Yes.
If he is not after acquittal, my lord, he has also should be joined this joined his service. But he and when it was acquitted, final.
How he can be joining after the acquittal? Unless the dismissal is set aside, how he can claim to join? He cannot. Under which law?
My lord, dismissal. That's why, my lord, we have come before the Honorable Learned Tribunal Court. We have made an application, but my lord,
That tribunal court, you have made an application after acquittal or before acquittal?
after acquittal. After acquittal, and my lord, not only
Which
that,
way? In which way?
acquittal order is there. They have made.
There is a dismissal order.
Yes.
You say that for the same charge, there was an FIR.
My
The
lord.
FIR led to criminal trial. In the trial for the same allegation, you have been acquitted. This is your case, if we have understood properly.
Yes.
So the dismissal order, was it challenged that now I have been acquitted in the criminal trial? Please set aside the dismissal order.
My lord, in way, my lord.
Which way? That is what we are asking you.
No.
Where is that prayer? In which way?
My lord, when it was I am acquitted, then I have crossed the age of superannuation. 2010, my lord, I have acquitted. But my lord, our
Still again we are asking you, relying upon the finding in the criminal trial, did you challenge the dismissal order? If you have not challenged the dismissal order, what you can get? Maybe, we don't know. There are judgments either way of the Supreme Court. In every case, acquittal in a criminal trial will not ipso facto help you in the departmental proceeding. In some cases, if it is based on the same set of evidence, everything is examined. In appropriate case, the court may hold that relying on the criminal proceedings conclusion, disciplinary, the punishment may be interfered with. We don't know. But where have you challenged that? Unless it is set aside, can you get anything?
My lord.
In the present way, you have not challenged.
No, my lord.
Earlier one OA was filed, dismissed. After acquittal, no OA filed. Then what can be done? Then
Well,
what
your
can be done?
lordship, I'll take it up next week. I will.
No, what next week? Everything is there now.
No, my lord.
What will happen in next week?
There are another WPST was there, my lord.
Yes.
Do not know where is that. I do not.
No. There is no other WPST.
Yes, my lord. In the year 2006.
Where is that? Show from your OA. Now the OA is on record. Show from your OA.
OA is, my lord, that is separate way. That is not.
Madam, you have filed an original application before the tribunal.
Yes.
If you have chosen not to bring those facts before the tribunal, you cannot do it now. So we are asking you, show from the OA where you have said that other WPST was also filed. Show from the OA.
My lord, that is not corroborated in this
Then
petition.
what can be done? You cannot improve the case. Whatever case is there, that only you can argue. Where is the dismissal of the earlier OA?
Well, dismissal of the earlier OA in the year, my lord.
2002.
2002. Thereafter, my lord.
Where is it? Which page?
Your lordship, kindly see page 25, my lord. Supplementary. Supplementary name. Original way. Your lordship. Supplementary page 25. Well, we have written that. Well, your lordship, kindly see. এখানে হয়েছে কিন্তু পেপারস তো দাওনি না না কাকে না আগেও তো আমরা ওয়েতে তো বলি And your lordship, kindly see the page 64.
Yes, we have just read it.
Grateful.
What did you do after that?
Thereafter, my lord, we have, my lord, all the given representation before the authority as per this honorable this way order. My lord, but they did not take any action.
Order of the tribunal is of which date? 2011.
2011.
And you filed representation in 22.
Yes. No, my lord. Before that, we have filed after acquittal and also
After the tribunal's order of 24/8/2011.
Yes.
When did you file the representation?
My lord, thereafter filed which representation করা হয়েছিল পেজটা বলো my lord, on 13th December 2011 কিন্তু ইয়েটা কোথায়?
13 December 2011.
Yes.
Where is that application?
Right now it is not available. And because my lord, that application was not corroborated in the way.
Then how the tribunal can consider?
My lord, your lordship, thereafter, my lord, your lordship kindly another order, my lord, your lordship kindly page 66.
66, that's why we are saying after
Yes.
11 years.
After 11 years.
Then you got liberty from the tribunal to do it within 1 month.
That before that we have given, my lord.
Within 1 month, by September 2011, you had to file.
In December was made.
But that is not within 1 month. You see page 65.
My lord, my lord. That was not done.
Then what?
Court petitioner was very aged.
And what is this? Page 69. What is page 69?
Page 69, my lord.
They have filed appeal against the acquittal.
Yes.
State has filed.
State has filed.
What happened in that case?
My lord, dismissed in presence of all parties as state. My lord, your lordship, kindly see the page 62 of supplementary affidavit.
62.
হ্যাঁ দুটোতেই অর্ডার আছে my lord, your lordship, it was dismissed. Your lordship, page 62, your lordship, kindly see supplementary affidavit, page 62. এই তো acquittal order to that. দাঁড়াও. Thereafter, state has preferred an appeal before this honorable court.
Again, we are asking you what happened in the appeal.
Dismissed.
Where is that?
My lord, that was, my lord, your lordship, kindly see the page 89. 89 না তো এটা অর্ডারটা কোথায় সাপ্লিমেন্টারি এফিডেভিটে দিয়ে পেজ কত 89 তো ঠিক আছে না 89 তো এর অর্ডার সাপ্লিমেন্টারি এফিডেভিটেই তো থাকবে সেটা কত নম্বর
That is not relevant.
Your lordship, kindly see page 87. Page 86 is, my lord, application for condonation of delay listed for admission. It was stated thereafter, my lord, we have not received firstly certified copy. Certified copy টা কোথায় পরে তো সার্টিফাইড কপি তুলেছিলে that was dismissed. আলাদা কপি থাকলে দাও কোর্টকে দেখাতে পারি এটা রেখে দিয়েছো কি করো my lord, your lordship, kindly এটা তো একটা ওটা ওর লাস্ট এটা তো দাও না তাদের কপিতে আছে এই কপিতে নেই আমার কাছে নেই মানে ডিসমিস আছে এটা তো ডিসপোজড অফ আছে এখানে তো তুমি অর্ডারটা কপিটা করে দাও এক্সট্রা কপি থাকলে সেখানে দাও যে কপি যদি আছে ওটা না ওটা পাসওয়ার্ড তাড়াতাড়ি দিন বলেছিলাম এই অর্ডার গুলো বিয়েতেও করে এটা কেন এটা এইখানকার ওর My lord, may I supply this copy or Xerox copy of appeals order?
What is that?
My lord, criminal appeal has been dismissed.
No, forget about criminal appeal. What have you done? Dismissal has not been challenged. Then what can be done?
Dismissal order.
Unless dismissal is set aside, you cannot get any benefit. You have not challenged dismissal in present or in present way also you have not challenged dismissal order. Nowhere. You got 1 month liberty in 2011. You did
Yes.
not avail the liberty. Again, you have filed away in 2014.
This is wrong.
What can be done?
That's true, my lord. This is
Till now, there is no setting aside of the dismissal. Then how you can get any benefit under retirement dues? You cannot.
My lord, your lordship, kindly see once, my lord.
What was the OA 602 of 2014 filed for?
All papers are not with me. That's why he is now 80 years old. But
Nothing can be done. Now nothing will be.
your lordship, kind give liberty to make a fresh application.
No, no.
Nothing, whatever submission has
No
been made,
liberty
nothing is on
now. Enough
record.
is enough. Now for 12, 13, 14 years you have been.
Yes, my lord. That's true.
There is the reasoned order of 23/3/22. It is on record anywhere. 23/3/22.
The petitioner wrote a letter to senior law officer praying for fixing the hearing in the matter as per previous notice. 602/2014 এটা 602/2014 এটা আমাকে আলাদা করে দিয়েছিলেন।
Yes. You have filed another way in 2014.
Yes.
Thereafter in 23 also. Can be done. Yes, take down. Heard learned advocate.
Item number 14.
Item number 14, my lord, I am appearing for the petitioner, my lord, in this matter, my lord. I am led by Mr.
State authority led by Mr. Chairman.
My lord, here, my lord, my grievance is, my lord, for the non-release of, my lord, pension and gratuity, my lord. My lord, before I place this case, my lord, the FIR, my lord, the petitioner is involved in a criminal case, my lord, and that is pending, my lord. So, my lord,
Instituted while you were in service.
my lord, my lord. My lord, the FIR copy is, my lord, not legible, my lord. Even
Not
the
required, not required.
even the, my lord, original application is also not legible, my lord. I am only praying, my lord.
So what is the issue?
My lord, my issue is, my lord, that the pension and gratuity should be paid, my lord, because, my lord, in
So
terms
let us see under which provision
of
it has to be.
DCRB 1971,
Yes,
my lord.
let us see.
My lord, my lord, I want to file one supplementary affidavit. my
Sorry,
lord.
no. First make out a case, then we'll see.
Led by Mr.
My lord, I am appealing on behalf of the petitioner.
So you are getting the interim allowance.
Yes, my lord. As well in respect of same matter in school education, provisional pension. Interim allowance and provisional pension is same. In
No, it is not
DCRB
the
Rule
same.
1971.
It is
My
not
lord,
the
in terms of Rule 1971, DCRB 1971, it is what? Term as
Yes, you are
interim
getting
allowance.
2/3 of
Yes,
interim
my lord.
allowance. You
As
are
per
not
Rule
getting
40.
provisional.
My lord, my prayer is as per Rule 14 of the DCRB 1971, petitioner is entitled to full gratuity.
So under which provision? Let us.
Yes, madam. I'm placing. And my lord, my submission criminal case was registered under. I have taken instruction from my client. FIR was registered under section 302, 304.
So 302 does not involve moral turpitude.
Yes, my lord. And criminal case has no nexus with this service. No proceeding has been drawn up.
Where is the nexus required? Under which provision nexus
I
is
am
required?
placing some judgment in this honorable court.
First provision, then judgment.
Yes.
So under which provision a nexus is required?
Yes. My lord, this is Rule 14. I'm
Hmm.
placing.
Read Rule 14, we have it.
DCRB 1970. Side থেকে সরবে তবে তো বলবো।
Where does it say that it should have a nexus with the
Yes, in place.
service?
Criminal proceeding. Rule 14. A government servant who returns from service but against whom criminal proceeding involving moral turpitude are pending in a court of law shall not be sanctioned any pension, not gratuity, until the termination of the criminal proceeding. An interim allowance not exceeding 2/3 of the pension that granted during the pendency of the such proceeding in case of hardship. If he is convicted on a criminal charge involving moral turpitude,
That is not applying.
Yes,
There is no question of conviction.
shall not be entitled to any pension. Compensatory allowance may be granted subject to the same terms and conditions. My lord, my submission petition is entitled to get full gratuity and covered by Justice Datta's judgment.
Only gratuity.
Yes, only rule. Gratuity and
You are not claiming pension.
no.
All right.
He is getting interim allowance.
No, that you will get.
Yes.
No, he was saying perhaps that pension and gratuity both has to.
And I'm placing some judgment and my lord, before the single wage matter. The teacher was convicted under section 302. Appeal is pending. They have released on bail. They are getting full pension and hold that. Honorable court hold that. Criminal case has no nexus with this.
No, now let us see what the tribunal has done.
Tribunal, yes. Lordship has completed 51. That's from 51.
So you have approached the tribunal for gratuity, pension, arrear pension, and everything. Therefore, it has been rejected.
Yes.
You cannot get everything.
ये जो नाम दिया
Yes, whether 10-2 applies or not, that is the only issue. Whether 10-2 will apply or not. We have passed one judgment. Oh, the earlier bench.
Yes. No,
You have that judgment.
no, I heard the fact on that day.
10-2 will not apply.
Yes.
Because 10-2 is for
10-2 is where departmental proceeding.
Yes.
departmental or judicial proceeding in which a loss is likely to occur. Therefore, it means in relation to service.
Yes.
14 is for if
Yes.
it is relying on perhaps rule 8,
Yes.
which says that good conduct is a prerequisite. Where is that judgment? You want us to write the judgment again?
And I'm always Justice Datta's.
Yes, His Lordship Justice Datta's judgment. We have considered that. We have considered this judgment.
Jani, Sami Senis.
Can you
On
get
that day,
the?
I have heard the matter, my lord. But
On that day, you have heard the matter.
yes, Malayalam, I am placing some judgment.
না ওই জাজমেন্টের
কপিটা নেই
কোন ম্যাটারে দিয়েছি
Since we have already decided.
Yes, ma'am.
বার করে দিয়েছি
Get that judgment. Mr. Sen, also you can also find out. I don't know whether you are appearing or Mr. Mukherjee was appearing in that.
I think my lord
I don't think you were appearing. Perhaps Mr. Mukherjee was appearing. So just find out that will.
14 and 17 will be similar matter.
14 and 17. 13. Wait, 17 will be called. The short issue arising.
To 19 19.
Item number 15.
This is my affidavit service. And on the last occasion, your lordship directed the state respondents to submit the affidavit in opposition. They have not served yet and not.
My lord, I am led by Mr. Shishanu Bandyopadhyay. The affidavit is almost ready and it is yet to be affirmed. Please grant me 2 weeks time. Sorry, my lord.
Yes, served on all the respondents.
Yes, your lordship.
You represent all the respondents.
For the state, my lord.
Yes, sir.
Aryan is here.
In an affidavit or in opposition.
But in this matter, your lordship, my lord, I'm led by the learned senior advocate, Mr. Anindo Kumar Mitra, your lordship. Lord, perhaps he is not keeping well, your lordship. I'm praying for this week's time, my lord.
Lord, this matter, the impugned order, my lord, was, my lord, challenged by the PSC, my lord. Your lordship may remember that matter is pending, awaiting for judgment. And, my lord, the same impugned order, my lord, during the course of hearing, my lord, learned additional government pleader, Mr. Mukherjee said that the Home Department may file a writ petition. Your lordships adjourned the matter for substantial period. And, my lord, they couldn't bring to your lordship's notice that this matter is pending. So, my lord, once the matter was heard by your
As a
lordship,
last
the other
round, my
bench,
lord,
my lord,
I'm praying accommodation on his personal ground, your lordship. Mr. Mitra's personal ground, your lordship.
your lordship may look the order, my lord.
Not required. When he comes, we'll see everything as prayed by the learned.
Yes, similar matter. Petitioner was a upper division clerk, lower was promoted as upper division clerk at Alipur, additional district sub register. In 1998, thereafter, criminal case was initiated under section 463, 465, 467. After the petitioner was suspended 24 June 2008, suspension was revoked. He was allowed to join his duty. And as per Rule 14, my lord, petitioner is entitled to get
Let the
Same matter. 4970. Eighteen.
Number 11 for in a fixed matter, my lord. For that reason,
please use the mic.
I'm for the petitioner, my lord, led by Mr. Firdaus Samim. He is engaged into courtroom number 11 in a fixed matter, my lord. For that reason, I'm praying for not today.
I was engaged in courtroom and left.
As prayed, list after 2 weeks.
Yeah. Item number like.
Okay.
19.
Notice served.
All notice served supplementary affidavit as per your lordship. annexing the scheme of 2008 and 2014. That was also served.
Please see the last order.
Last order. Supplementary by taken on record to notice the respondent speed post service. My lord, delivery service.
Yes, who is appearing?
Well, as per your lordship direction, 3 times I served notice to the government pleader office.
Just see what you have stated in the notice. We asked you that you should indicate it will be taken up on such and such date. You have not mentioned. You are mentioning order passed by some other judge.
Then direction given any one of the my lord learned advocate appearing my lord appeared before your lordship. I served copy of the application.
Give it. Why don't you? The notice. Monday.
Next Monday. That one.
Twenty.
Lord, I beg to appear on behalf of Lord the applicant. Lord, on last occasion, Lord, your lordship was pleased to directly to file Lord supplementary affidavit, placing on record as to the advertisement, the recruitment process. তো ইচ্ছাঘাতী রাখিও না, এটাও একটা ব্যাপার। RK, RK,
Yes.
Milord, my case stands with Milord page 20 and 21, Milord. I was Milord provisionally Milord appointed as constable.
That is all right.
Milord.
That we have seen.
Milord, page 21, Milord, they have.
You were recommended by the commission,
Milord.
but the verification has failed.
Failed.
Yes.
The reason being, Milord, they are asking me to provide documents of my parents and grandparents prior to 1971, which I could not. I have given my birth certificate, which has been verified and it is genuine. Because during the pregnancy of my mother, my lord, my father left away, my lord. So I cannot give anything so far as my father is concerned. And I don't even know where he is. But I am the citizen of India and my date of birth, my lord, is reflecting in my birth certificate. I have given it. Despite that, my lord, they withheld me and which resulted, my lord, filing of appropriate application before the tribunal. So the tribunal was of the opinion that since it is a very premature stage, so we cannot interfere with the decision. But there is no written decision, my lord, or order being served upon me saying that whether I will be absorbed or my appointment would be cancelled.
When it says for processing your case, what does that mean?
My lord,
Does it mean that you will be appointed or does it not mean that you will be appointed?
my lord, kindly takes up page 21 once.
Kindly takes up page 22, not 21.
22, my lord, is their query to me.
This is the impugned order. This is the order you have challenged.
Yes.
Now what does it say? Read the first line. I am to request
you to submit the following documents to this department immediately for processing of your case.
for processing of your case. What does that mean? That if you submit it, you will be appointed.
No, my lord, kindly takes up the previous page once, if your lordship, my lord, kindly.
Why should we? This is a later order. Why should we go to the earlier order?
No,
That is of 13.9.
My lord,
This is of 22.9.
my lord, here, my lord, it is admission on their part. Kindly takes up, my lord, 1 second, my lord, for my satisfaction.
What do you want to show?
As for the record, your police verification report has been pending till date. As your police verification roll has been sent to IB so and so Barakpur by wide office memo so and so dated so and so SB Barakpur, as discrepancy arises regarding your CA or and nationality. Thereafter, the matter has been further sent to the assistant secretary. So
here also it is said it is pending.
And the page 20, my lord, it said.
No, how you are saying that we don't know whether it is
selected unreserved category. This is their admission.
Why are you reading those things? How it is relevant? The point is whether you are to produce the CA.
Subject to verification. Subject to verification.
Why you should not produce this? That is the only question.
Well, at 71 documents, prior to 71 documents of my parents and if they are asking me to provide documents so far as my mother is concerned and my birth is concerned, I can provide. But if they are asking me for the production of my father and my grandparents, I cannot.
Why
the reason is
why this query has arisen?
I don't know. Prior to this, there was no communication to that effect.
They filed any reply in the tribunal?
Yes, my lord.
Where is the reply? Yes, Mr. Sen, why this issue has arisen?
instead of my lord going straight to the my lord the filing original application challenge. This is not a matter to challenge before the court of law. If there is any difficulty, because the matter relates to that with regard to proof of his nationality, it is also my lord, it appears from the my lord the application which was invited, the notice inviting application which is annexed here to
Yes.
in the supplementary affidavit. It appears from the my lord the eligibility serial number 3.
Yes.
That must be a citizen of India.
Is there in every advertisement.
Yes. Now, my lord, if there is any difficulty to
No, why the issue has arisen, that we are asking you.
the issue
Have you demanded such a certification from all the candidates?
that I cannot say, my lord.
No, in your reply, why you have what you have said?
Page 45, the reply.
Why only from him? We don't think that you are asking everyone to establish their
It may not
citizenship.
be that only for him. Since I think it's a my lord, the recruitment in the my lord, the police department. My lord, I think it is not that the
Have you stated what is the infirmity in the verification?
infirmity so far page number 19 is concerned. It is therein. So far page number 20. 21. 21, it is pending also for that. That the discrepancy arises regarding your CA and nationality. Therefore, the matter has been further sent to the Assistant Secretary to the Government Opposition, Home Department, Internal Security Branch, Secret Section. Then again, there is a rider. If satisfactory police verification report, medical examination report have been completed, then it was followed by this. Well, let him write, my lord, and let it be considered that what is his difficulty, and let him say that whatever the documents I have produced or I am ready to produce, these are satisfactory to prove the nationality. Let him say before the recruitment authority, the recruiting authority. Something must be there, well, to dispel the cloud it having there. So, because I think they have taken this step because it's a recruitment as a police personnel.
But my lord, in the may I, my lord?
Birth certificate is date of birth.
What is your date of birth?
1993, my lord. 1996, my lord, page 26 onwards. And my lord, it is not the case of the state that documents submitted by me are forged.
Yes, that is their case.
Certificate issue.
That is their case.
No, my lord, that is the
Birth
reply, my lord,
certificate issued
reply
on
not
23rd December 2021. Produce the birth certificate issued on
my lord,
23rd
since my lord, it
December
was handwritten then, my
2021.
lord, I had to procure it. So, my lord, let there be an inquiry from the end of the investigative.
They have already inquired.
No, my lord, not inquired, my lord.
Yes.
No case, specific case has been initiated.
Have you read their reply? Have you read their reply? Then how you are saying they have not inquired? If you have read, then you would not say that they have not inquired.
During verification, my lord, page 25.
Please read page 45.
45.
Yes.
During verification.
What during? You will skip
second
the upper paragraph. You will skip the.
Accordingly, in compliance with memo number so and so, West Bengal communicating ORG so and so was sent from Reserve Office, Barakpur Police Commissioner to 128 professionally selected candidates, including the instant applicant, through officer in charge of the concerned PS, and asked them to collect blank verification form so and so from Reserve Office, Barakpur Police Commissioner to submit filled a verification form duplicate along with attested copies of connected papers and testimonials by so and so for verification of their character and antecedents. Subsequently, the instant applicant submitted and filled a verification form in due time. Accordingly, all the documents were sent for special branch for verification of character, antecedents, and paper testimonials. The verification in respect of Saurabh herein in the instant application was started by the then Assistant Special Branch, New Barakpur. During verification, the ASBO, New Barakpur Zone, found one discrepancy in proof of identity of India and Indian nationality in respect of Saurabh. Hence, Saurabh requested several times New Barakpur Zone to produce the documents in favor of residential proof of Indian nationality, but Saurabh herein failed to produce the same. So, here discrepancy and the document relied upon or documents for the employment forged, that is not the story.
Only if it is forced, then only you can be disqualified. There is some rule that unless there is forgery, you cannot be disqualified.
I have given my birth certificate. I have given my school living certificate.
Why you will not produce the proof when they are asking you?
Proof, my voter card. I have given my voter card.
Cannot.
My voter card, my mother's voter card, that is my residential proof, my lord.
There is nothing contemporaneous to your date of birth.
My school documents, my lord.
Of which year? You have submitted that?
My lord.
Where is it?
Page number 25, my admit card of Madhyamik.
Page?
2011.
Page?
Page 25,
Madhyamik does not establish your citizenship. There is a doubt has arisen. The matter was inquired not only by the police officials but IB also. You are not reading what you're because you have not read, therefore we will not skip.
No, certainly.
So therefore the discrete inquiry has been done by the Superintendent of Police Special Branch, IB, everybody has examined, they have found discrepancy. To clarify that, they are asking you to produce something. You are not even responding. You have not even told them that for these reasons I cannot give you this document. Why you should not respond to them? And after they required you to do this, you have not responded. They have also cancelled your candidature.
I have by way of
what? No, my lord, they have cancelled your candidature.
Subsequently.
Yes.
Subsequently,
that has also been cancelled. Was that challenged before the tribunal?
That cancellation, we have come to know during the pendency of this application,
During pendency of?
During the pendency of OA application before the tribunal.
Therefore, we are asking you, did you challenge it before the tribunal?
We have taken it in our rejoinder,
How? Wonderful.
We could not challenge it since it
you
was.
You did not. Don't say you could not. You did not.
You
could have filed a MF challenging it. You know there is a procedure for challenge. You did not challenge it. So what can be done? If you are not diligent for your right, what the court can do for you? Why you are asking for 71? Why? From where do you get that date? But, what is the significance of that date? Because he is born in 96. 96. Why 71?
I think, my lord, there are some, my lord, the gray area, and that is why. And one thing, my lord, kindly consider one thing, that the birth certificate also issued in
21 that you have already said, but why 71?
Possibly, my lord.
Whatever you are demanding, huh?
1971, my lord, the influx of, my lord, that the
No, but then does the police authority have the discretion to ask anyone for a proof of particular date? There must be some decision of the government based on which they have made this demand. So you have to come out with your bona fides. Why you have asked him for, under which provision, whether there is any notification issued under the Citizenship Act or some decision of the state government. Why 71? You file a reply, then we'll see.
instruction I have not taken.
File an opposition. The
Department, my lord.
Was disclosed long back.
And I was to take that information by way of RTI, my lord. Kindly see, my lord, there was no direct communication to me showing that. Kindly see the dates and, my lord.
chosen not to check. That was cancelled long back.
And my lord, kindly have a look at that, my lord, the internal page 3, that communication. He was informed regarding that, my lord.
He is saying he has dealt with it in his rejoinder.
On 11th August 2023, it was informed.
Yes, he has dealt with it in his rejoinder. Still, he has not challenged it. Why he has filed the writ petition?
I cannot say that it was not in my knowledge.
Where is your rejoinder?
My lord, page 52.
Where is your rejoinder?
Start with page 52, my lord.
Page?
Page 52.
Nothing. You have done nothing.
My lord, page 55.
Read 57. That is the only what you have said. Nothing else.
The instant application received, my lord, kindly takes a 55.
very-
55, my lord, paragraph 3. The instant applicants received letter dated 11/8/2023 from the Reserve Officer Barakpur PC with reference to memo number so and so, Deputy Inspector so and so, that that his candidature for the said post has been cancelled with immediate effect for want of proof of identity and nationality by order of West Bengal Police Directorate under the reference. As per 3 of the then, my lord, as per section. Then, my lord, as per section 3, my lord, I have dealt with, since it was received during pendency, my lord, and the tribunal was of the season of the matter, my lord. So they have taken this point during pendency of this, and during pendency of that OA application, my lord, this has been issued, my lord, since you have not challenged it. The page 55.
You are saying how nationality can be a relevant factor. This is your rejoinder.
My lord, what I had taken in my reply.
You see what you have said.
My lord, I have seen.
How? That is the basic qualification in the advertisement.
The first
must be a
I'm Indian
citizen.
national by birth.
Then
That should be
how
clear.
you are saying that how
Every affidavit,
nationality
my lord,
can
will
be?
declare that with the first line.
How you can say that how nationality can be a qualifying factor? Nationality is a qualifying factor.
my lord, the
It is
cutoff
not
date-
open for foreign nationals.
The cutoff date, my lord, has not been mentioned in the advertisement. If the cutoff date, my lord, would be mentioned in the advertisement, my lord, we would
But you have not challenged the cancellation order. Nothing has
my lord,
been.
I have dealt with my lord since my lord, I do not or I have not since my lord, it was served upon me, my lord, during pendency of OA, and OA, the tribunal was in the season of the matter. So my lord, that actually tied my hand, my lord, for not challenging that order, my lord.
Coming from a lawyer, it is difficult to accept.
No, my lord,
The petitioner could have made such submission.
my lord, the learned trial court, my counterpart, my lord, chose my lord not to, my lord, since the
Say that, don't say that your hands were tied. You had all the opportunity in the world. There is provision in the
counterpart, my lord, it is the
Administrative Tribunal Act and rules for challenging. Why you are saying hands were tied?
it
You
should
have
have
chosen not to challenge it.
ought to
You
have,
could
my
have challenged.
ought to have, my lord, the
Once you have not
counterpart, my lord,
challenged the
has not advised
cancellation,
my client.
what will be done if you have not challenged the cancellation?
Lord,
That
this was-
also cancellation of 23.
This-
Till now you have not challenged.
My lord, this issue, my lord, has been taken care of by the tribunal, my lord. Also, my lord, kindly takes up the order, my lord.
Was not specifically brought to the notice.
Tribunal, my lord, has not gone into the merit of the case.
Can you show us any piece of paper that you have responded to their queries? Any single communication that you responded to their queries? You could have said that we are not obliged, I'm not obliged to give anything. I have already submitted. This is a baseless demand. Anything you have said about this query?
My lord, it will reflect, my lord, from my reply, page 55, that pursuant to their query, my lord, I have submitted my voter card, Aadhaar card, proof of literacy by your scheduled Madhyamik Pariksha.
That is nothing. That is your rejoinder.
That is my rejoinder, my lord, and this has been pleaded in my OA also. And that has not been, my lord, controverted by them that I have not submitted these documents.
Again, we are asking you after the query was made that you have submitted with your application. Those documents have been sent in the verification. Once they have asked you to submit this proof, did you respond to that by any communication?
Again, my lord, when this officer came to me, my lord, I have given the same documents.
Where is the response?
Page 23, my lord, kindly takes up. Page 23, my lord, takes up. My lord, I have received this 22nd 9/2022 of asking the documents prior to 1971. Then, my lord, I have come up with this application through my learned advocate, my lord. Where application taken? Where?
Where is your reply at which page? Your rejoinder is at which page?
45.
No, that is not your rejoinder. That is the reply.
55.
Huh?
It starts with 51.
55.
52. Start with 52. 55 was the relevant page for.
You had received that cancellation note. It's not that you had not received. You had received that cancellation.
Well, during pendency.
You read page 55, paragraph 3.
The instant application.
Received the letter.
The instant applicant received letter dated.
Yes, it is not said that it was never served and now for the first time it is being.
Kindly, my lord, takes up the date of filing of this OA. During pendency of OA.
Yes, so it was served on you.
During pendency of OA.
Obviously, yes, in August 23.
While they, my lord, came up with the application of.
No, it was served on you directly. You have accepted it. The instant applicant received the letter. You are not saying that it is only by way of reply that I have received.
After filing of the bill.
That is correct. After filing is correct. Because the OA was filed in 23.
Have a look page number 46. Page number 46 is the under the running page 3 of the my lord the position or benefit file above state. Page number running page 3, page number sorry, running page 46, internal page 3. The second paragraph. Accordingly, on receiving the order, a communication having Virgin number such and such of 11th August 23, and the order was duly to the petitioner through the OC New Barrackpur PS. He has not denied that in his reply that no, this averment is not correct.
No, he has accepted.
Yes,
He has a page 55, he has accepted.
It's not correct that only as an annexure to this.
No, it was during pendency, not as an annexure. He has taken no step, and the matter has been disposed of after 2 years. In 25, all this time he has not taken any action. Yes, take Lord Learned Advocate for the
You can challenge now 23 order. In
But
20,
subject to my lord, your lordship, my lord, kind academically, my lord.
the learned advocate for the petitioner submits that he will be assailing the
Twenty-one.
On the ground of Mr.
2 weeks. Not possible in this week. An accommodation.
Twenty-two.
My lord, I flip your honor. Yeah.
24/9/79. Where is that notification?
That document was produced by my learned senior friend, Mr. Rai.
You have a copy? Mr. Sen, where is that 24/9/79 notification?
79. That is
He's an employee of, your employee of?
Sub-assistant engineer. Now, I was charge sheeted in 2013, and thereafter I was suspended. I retired from service in 2014, on 31st October.
Same year.
2014.
And charge memo is of?
2013. In 2022, I was honorably acquitted.
Acquitted?
The disciplinary proceeding initiated, and was found that ultimately it was
No, 13 departmental proceeding was initiated. So you were exonerated.
exonerated in 2022.
22.
For 9 years, my lord, the proceeding completed, and thereafter.
What is the date on which you were exonerated?
15/12/2022.
22. And what is the date of your superannuation?
Superannuation, my lord, 31st October 2014.
Sorry?
31st October 2014.
14.
14.
And what is the date of charge memo?
4th June 2013.
And when you have been paid the gratuity
In
dues?
2013, my lord. 2023.
Date, please.
Got the pension leave encashment page 42. Leave encashment on 20th April 2023. Retiring gratuity on 26th July 2023.
22.
23.
23.
And area pay and allowances on 12th June 2024.
Manali.
Pension was paid on? Pension, you must have been getting the interim allowance 2/3.
According to my instruction, my lord, that was given after I was exonerated from the.
Where have you said? In your OA, let us see. That no interim, no provisional pension or no interim allowance was paid during pendency of the proceeding? Without verifying the facts, how you make submissions is very surprising for us.
Lord, paragraph, if your lordship kindly consider page 6, paragraph 11.
Where have you said that no provisional pension or interim allowance was paid?
Paragraph 6, 11.
What does it say?
It says that as the retirement dues and other areas, including pension and salary, were withheld due to the pendency of the. So it appears to be that that was withheld.
It appears to be from this, that no interim allowance was paid and no provisional pension was paid. And you took no steps for so many years, knowing that it was due to you.
There is no other than this averment, there is no.
Then you should not say these things. That's not the case of your client. He has specifically stated in 8, 9 and 10 what all dues have been paid. These are the dues which were withheld. Earned leave on 24-23, sanctioned retirement gratuity in August 23, and arrears of pay and allowances, probably increment and all, in June 24. Nothing else. And you are saying that no provisional pension was paid, no interim allowance was paid, making a submission of fact without any foundation in the pleading. What are the amounts? Where is the disbursal of these amounts? P3 is at which page?
pension payment order.
This is the leave salary, 300. Then P4 is at page 43.
That's on account of retiring
gratuity.
Issue is only limited to his prayer for my lord interest on
Yes.
retirement.
Yes, yes.
Relief. That
Correct.
is short form.
Yes.
And my lord, that is my lord at page number 31. That is internal page 11 of the weight.
Yes, we know that he is he is claiming interest, but what are the dues that on which he is claiming interest?
He has not said anything, only said that he is interested and he and no interest has been paid. Otherwise, he is entitled to. And that also prayer is not correct. In the prayer portion, he said that on and from 1st August 2010, how can it be? He is superannuated 31st of October 2024.
The tribunal's order that you have challenged, why you have challenged the order?
One of the twofold issues, my lord. My lord, I should be very candid to my lord that the application has not been properly adapted. My lord, the issue has been relegated to the authority.
Yes.
At the very outset, the authority who suspended me for determining as to whether I am entitled to get interest or not. And that too at the rate of 6%. That is why I am before your lordship.
That was your submission.
Yes, sir.
Then how can you challenge it in a rate proceeding?
The rate of interest.
That is your submission.
Yes, my lord.
What? Yes. Then how you can challenge it?
Or the learned tribunal had been pleased to relegate the issue to the authority.
No, you asked for it. That is what we are saying. You read paragraph 3. You say that I'll be happy if you direct them to consider. And that is what the tribunal has done, and you are challenging the order.
That is on 2 occasions, rate of interest, lordship, and will consider.
So everything has to be considered.
The learned tribunal had been pleased to direct the
Mediated.
authority. Direct the authority in the event if it is found I am entitled to get interest.
Is that the
That should be restricted to 6%.
My lord, directing the authority concerned.
Why not 50%?
That is
Why not 50%?
If your lordship kindly permit me, I can place a judgment of the honorable apex.
Yes.
It has been held that paragraph 6 and 8. Lordship kindly consider paragraph 6 and 8.
Here it was a simple withhold. Otherwise, and here the facts are different.
That's all.
One more, if your lordship kindly permit me, that one of the honorable coordinate bench had been pleased to wherein a criminal case was pending, if your lordship kindly consider paragraph 23. Sir. Paragraph 23. The honorable coordinate bench had been pleased to pass an order directing to pay interest at the rate of 10%.
Paragraph?
Paragraph 23. See that there was a criminal case pending against the income.
The 72 Act will apply to a state government employee.
Payment of gratuity.
Yes.
But actually, I have handed over to cite the proposition that I have made.
There is no proposition. It says he cannot wriggle out of the 72 Act. So it will apply to a state government employee or a central government employee. What is the law? Tell us.
Pension. Pensionable gratuity. That is a pensionable gratuity. That is under the Gratuity Act.
So therefore, this judgment has no application to your case. This Gratuity Act does not apply to government employees. They are governed by a different set of rules. Anyway, heard learned advocate for the writ petitioner and the
23,
Not today. As spread list after 3 weeks.
December.
24,
I'm for the state. Lord, I appear for the petitioner led by Learned Senior Advocate Mr. Dibendra Anwar. He is online, my lord. কোথায়? আমি পুলিশ প্লেস করছি না আমি কি করবো? Lord,
What is the issue?
issue is, my lord, the petitioner before lordships are, my lord, the senior medical officers. My lord, they were appointed on a contractual basis. Now, my lord, they want regularization and absorption of their appointments in the department. Now, my lord, they were asked to participate in the selection process against a sanction post. My lord, they participated in the selection process, and my lord, after being selected, my lord, against a sanction post, my lord, they have continued from 2011 onwards.
How many writ petitions?
Well, there are 2 writ petitions, my lord. In one writ petition, a bunch of doctors are there. In the other writ petition, my lord, issues are same. One writ petition is there, my lord. My lord, in this case, what has happened, my lord, the petitioner before lordship, my lord, initially, my lord, the department an advertisement was made, a selection committee was formed. My lord, if selection committee is confined, if lordship takes up the tribunal went on, my senior is here, my lord. Let the senior make his argument, my lord.
Yes, we are waiting for him to say something.
My lord, in this matter, my lord, I appear virtually for the petitioners. That both the matters are similar in nature. Lord, the common impugned order is before your lordship.
Yes.
Lord, the thing is this, Lord, we are entitled to be regularized since, Lord, we have fulfilled all the conditions stipulated in paragraph 3 of Uma Devi's case, and Lord, subsequent cases also. Now, Lord, I do not know, Lord, whether we are being opposed by anyone from the state government. Lord, in fact, Lord, I mentioned this matter before your lordship to take up on an urgent basis because, Lord, the petitioners are suffering, vacancies are available, they are not being regularized. They have, Lord, served, still continuing to serve, Lord, for more than decades. Lord, they are definitely, Lord, subject to your lordship's kind consideration. Lord, they are definitely entitled to be absorbed. So, Lord, if your lordship, Lord, considers the cases of the petitioners, Lord, subject to, Lord, what are being submitted by the state advocate, Lord, that would be, Lord, definitely, Lord, in your benefits in favor of the petitioner. Lord, we have served, my junior has served the notice upon the government.
They are appearing.
All right, all right.
Yes, I have seen both of them. Where is your initial appointment? On contractual basis.
Takes up page 48 onwards. 48. There are several appointment orders.
How many petitioners are there?
In the instant petition, my lord, the first one, my lord, there are 9 petitioners, and the other petitioner there is 1.
So 9 and 1, 10.
Yes, sir, 10.
Page 40?
48. 48, my lord. Thereafter, my lord, 51, my lord, with regard to all the petitioners. If your lordship takes up, my lord, a pay scale has also been awarded to them with a great pay. Page 47, if your lordship takes up, this is the selection committee. Page 47. Because High Court committee headed by the director, the additional secretary, the director of Ayurveda.
This is under the Ayush scheme. This is not in the state government.
It's
under the Ayush scheme. Ayush scheme of the government of India. You see, it is a decision of the Director General Ayush.
Your lordship is seeing at
Page 47.
47. The governor is pleased to constitute with effect from such and such a committee.
Who has issued the order?
The Director General Ayush and EO Special Secretary. My lord,
Yes.
your lordship will find the top, it's Government of West Bengal is there.
That is all right. That's all right. This is implementation of that Ayush scheme which is being done in all the states.
One thing has happened.
So you are not,
Scheme of central to be implemented by the nationwide.
Yes.
Statewide. Now, my lord, lordship will find the reasoned order. My lord, initially when application was moved, 2 applications were moved. My lord, directions were given in the reasoned order.
Contractual engagement here for 1 year. It has been renewed from time to time. While joining, you have given an undertaking that you will not claim because the Ayush scheme. That is how the scheme is. It is under a scheme. It is not against any sanction post of the state government.
Your lordship will find the sanction post is mentioned at page 63. 63, my lord. Your lordship kindly takes up
Page
63, my lord, 63. Well, this is a response to my RTI representation by the erstwhile advocate. Your lordship will find 5A and B at the bottom. My lord, your lordship will find page 63. Selection of SMAO were made on giving weightage to academic marks with relation to 10+2 UG and PG examination vivacy as well. All contractual examined of SAMO were made against sanction post. So, my lord, these are against the sanction post. And my lord, we have participated in selection process. We are continuing. And my lord, in the reasoned order, which was the second round of litigation, which is my lord, now before your lordship. My lord, the reasoned order, they have said only one thing, my lord. You have given an undertaking in the contractual. They have said in the contractual agreement, it said it's 1 month. You cannot reclaim any absorption and Umadevi.
Just see the way you have been appointed, walk-in interview. And such person will come in the regular establishment.
But in MBBS also, my doctors the same thing. They don't have a selection process of written examination or something. I will certainly say, my lord, with regard to MBBS doctors and other doctors, my lord, the health department, normally what they do, my lord, is a walk-in interview. 7 except, my lord, the technicians and others. With regard to doctors, my lord, this is what they do.
There is no recruitment.
No, my lord, no selection process of written examination, nothing is there. Well, I can say with certainty, my lord, I have dealt with many of them, my lord. In all cases, walk-in interviews are there. But your lordship will find one MBBS regulation order is also there. I think, my lord, that is also, I'm not sure about, my lord, whether it mentions,
There is no process. There is no procedure for appointment.
Well, only this walk-in interviews there.
Since you are relying upon Uma Devi, therefore we are making this observation. There is no compliance with Article 14 or 16. Anybody who comes, they will be picked up and there's nothing. Everything at the discretion of this 3-member body. That's why you have been given a contractual status. There may be, we don't know, you are saying we are not disputing that, but those appointments cannot be done like this. There must be a minimum marks specified, essential qualifications specified. Here there is nothing.
This is a selection committee which speaks of, my lord, what I get, my lord.
Just see what it says. Nothing.
It only says, my lord, the members, my lord, at that point of time, my lord, recruitment board, health recruitment board was not formed, and my lord, the powers from the PSC were taken away. So that being the situation, my lord, this committee was formed, as I'm told by my client, my lord. My lord, initially, all the appointments of doctors, whether in, my lord, allopathy, homeopathy, or Ayurveda, or Unani, my lord, initially it was done by PSC. Now, my lord, now the recruitment board has come into effect, my lord, health recruitment board. Now, my lord, health recruitment board does this. But this is the period, my lord, intervening period when the PSC's powers.
That is why they did it on contractual basis. Now they have formalized everything. They will do it in accordance with law. That all the more that clarifies why it was done like this. Perhaps there was some urgency to implement the scheme for promoting this Ayurvedic system of medicine. So they have resorted to contractual. How can you raise a claim for regularization?
No, your lordship can take up page 70 once. Also, it's not dealing with us. Well, this is dealing with one of the MBBS doctors.
Page
70. Well, the governor is pleased to regularize the service of 626 medical officers, block medical officers of health in the cadre of West Bengal Health Service, West Bengal Public Health and Administrative Service, who joined service on ad hoc basis. Well, same thing, they were also appointed, my lord.
No, ad hoc and contractual are two different things.
It's different, my lord, but the process they were appointed is the same.
So therefore, contractual is once it will remain contractual. Ad hoc can always be made permanent. The contractual person's relationship will be defined by the contract.
And my lord, the rejection order, which was assailed before the learned tribunal, and if your lordship takes the rejection order, which starts from page 117.
Did you file a reply before the chairman?
No, my lord.
Let us see. Let them file reply. Let reply be filed in by the. Order.
The first matter, WP, OA number so and so will cover. And there is no
Oh.
separate filing. Therefore, my lord,
Let them deal with
must be guided
only in the first case.
Lord, only one thing, Lord, subject to your lordship's Lord kind consideration.
Order
And what
passed in the
lordship
first
has observed.
order to be recorded in the first case. Second case, you record an order list along with the first case.
but we also use the reply.
What reply you file? There's nothing that. All right, you file it.
Lord, maybe just permitted to clarify, Lord, by a moment, Lord. Lord, contractual ad hoc, as your lordship has observed, Lord, the decisions, Lord, of the Honorable Supreme Court, Lord, from time to time, Lord, did not make any difference. Lord, your lordship keeps it for final hearing. Lord, I shall try to demonstrate, Lord, how we are entitled to be regularized.
Yes, call the next case.
Yes.
Lord, only thing, my lord, both the affidavits be kept, both the matters, my lord.
Yes, give it. 26.
Contracted.
Affidavit of service. Service, affidavit of service. As paid list after 2 weeks.
$26.11.
Another matter, my lord, which is item number 75. The Lordship, your Lordship, while sitting with my Lord Justice Bhattacharya, has heard the matter. This is regarding the horizontal reservation of civic volunteers. So, my Lord, this instant case is of civic volunteer. In the item 99, that was of home guard. And the issue is same, that the without filling up the quota of fixed for horizontal reservation, the authority.
You are referring to which matter? At which?
Item 99 on 30th
90.
99, the WPST 99 of 2024.
99 is WPST 200 of it.
Item number 75. Sorry, madam. Item number 75. On 30th June, hearing was concluded. While the issue, fundamental issue in both the matters are same.
So it should be listed with that.
Yes, my lord, it should be listed because, my lord, this item number 75, the issues were twofold. First, that the horizontal reservation was not extended to the applicant, and second was that the tribunal's order was to send for a consideration, and without waiting for that order, he challenged that order. So, my lord, these two were there. Here, my lord, the tribunal has decided the lease.
Who is appearing for the respondent?
Well, in item 75, Mr. Tapon Kumar Mukherjee, learned AGP appeared.
No,
for
no,
this
in
case.
this case.
In this case, my lord, Miss
You have not served.
Pooja Shao has last it was appearing before Puja vacation. Miss Shum.
No, there is nobody's name appearing for
No,
this.
my lord, it was adjourned on my ground. At 20.
You will appear
I appear for this case.
in 27th.
Sorry, my lord, both the matters can be heard together.
Reply was filed before the tribunal.
Yes, yes, yes. Reply was filed. Thereafter, a clarification was also filed. We
Learned Advocate General in this matter, Lord.
Oh, yes, what did you say?
I am led by Learned Advocate General in this matter.
So what?
75 WST 9924 issues two things.
I mean,
What do you want?
my learned friend is asking for the tagging of the another matter.
What do you want? You said you are being led by the Advocate General. You tell us what you want.
Your Lordship, kindly, if you
Well, kindly adjourn the matter.
But if your Lordship adjourn the matter, I can come with preparation on the next day. And what?
When do you want it? Tell us.
Next week, your Lordship.
Next week is not possible.
So my learned friend asking for
Well,
another matter,
any day-
75. I
any
do
day,
not.
my lord, subject
We
to-
are asking you. Why do you repeatedly say he is asking?
No, no, no.
What he has submitted, he has
I have
submitted.
already submitted before your
When do you want? You say you are being led by the Advocate General.
next week. I have said
Next week, it is not possible for us. Therefore, we are telling you. You said the Advocate General has
then
to
I
appear.
leave it to your Lordship. Your Lordship kindly fix.
So he will be available on any day.
Any day, not this in this week, but this week your Lordship kindly pardon me.
Sir, can you please just listen to what we are saying? We are saying this week and next week it is not possible. If we fix it on a date, that day again you will say we are being led by the Advocate General. So give me a date, give us a date on which we can fix it when he will appear.
নেক্সট উইকের পরে কি বলছেন জয় সাহেব, কি বলছেন জয় সাহেব, কি বলছেন? Any date, your Lordship, after next week, any date.
Mr. So and so.
Obliged, your Lordship.
May it please your lordship.
I'm led by Mr. Kollol Vasu on behalf of the private respondent, my lord. My lord, he is on his legs. My lord, I'm praying for a short Passover, my lord.
But that matter where your lordship held that was discussed amongst yourselves whether
Any breakthrough?
compassionate appointment.
Any breakthrough?
Here the learned tribunal has passed an order contrary to the rule. And Lord, there is a anyway, but if he is not, lordship will take it up on another day subject to.
Last day also, it was adjourned on his ground.
Yes.
But I'm praying for short Passover, my lord. He is on his legs. Should I kindly take it up tomorrow, my lord?
Today again an adjournment. Today again adjournment is sought on grounds of
Okay.
For the state. In this matter, my lord, I would like to sort for a short time because my lord, the learned government Peter would be, my lord, be addressing your lordship along with the learned additional advocate general. My lord, the new allotment of the
you want time. Where is the AG?
on next before court number 25, my lord, that he has requested if your lordship is kindly, my lord, gives time, my lord.
An adjournment is sought due to non-availability of the learned additional advocate general. Full stop. Matter stands adjourned 2 weeks.
But I have been working in under contract. On number 4, the group will try on contract basis. Contract employees. And my impression was my appointment was extended from time to time.
That mic off? Is that mic off?
My affidavit of service. My affidavit of service is there. The copy কোথায়?
Who is for respondent number 4?
Who copy देगा?
Respondent number 4, my lord, I am for the state, for the Polytechnic College.
So this Polytechnic is not a state college.
It's a separate entity, my lord, not the state government.
But I could not file the affidavit of service in duplicate. No, on the next date I shall file it. So kindly come to page 59.
But এটা আপনি জিনিস করতে পারেন। করাই যাচ্ছে না। এই যে কন্ডিশন আছে না, এই জন্য দেখাই যাচ্ছে না। আপনি এইটার বেসিস হয়ে তো চাইছেন।
আছে।
কিন্তু এটা প্রফিট মানে অ্যাপ্লিকেবল একবার করবো, সেইটাই আমি পড়তে চেষ্টা করছিলাম, ভাবতে পারছি না। এটাতে আমি
You want benefit of the memorandum of 15/7/2019.
that is page 49.
That is what they are claiming.
Yes, yes.
But my lord,
Yes. So how you will get the benefit of this memorandum?
I am contractual employee. Circular is this, my lord. And come to page 62, Lord. Well, I was appointed as a contractual employee, my lord. Page 21.
দুটোকে মিশিয়ে দিয়েছে, মিশিয়ে দিয়েছে।
6,600.
Yes, my lord.
Yes.
I am on the basis of that 6,600. I am now getting 5,000. 5,000. I am getting 5,000 only. The meager amount is 5,000 in total.
No, you have approached the tribunal for what relief? Where is your prayer in the way?
Page, my lord, kindly come to page 91. Please not for para 7. Roman 3.
Therefore, we are asking you. You are asking a benefit of 22,000 rupees per month.
That 22,000 rupees per month can be paid to you only under memorandum dated 15/7/2019.
Yes.
How that applies to you, that we are asking you. If it applies, then only you can get the benefit. If it does not apply, you cannot get the benefit. So how it applies to you? Tell us.
I am working on 20 years of service. On that basis, which is
That is at page 49.
Lord, my appointment is annexed P2 at page 21. Lordship, kindly see this.
Yes.
I was appointed in the year 1st December 1920.
We are asking you how memorandum dated 15/7/19 will apply to you for the third time, sir.
15/7/19.
Yes, we have been waiting. We'll wait for another 2 minutes. But please answer.
7/19. Distraction and recommendation. 49 please.
This is for certain boards and
Lordship, yes.
a star became surplus. So to provide them alternately, this memorandum was issued that they will be employed in other boards and corporations on the same level.
Line 6, sixth line.
Yes.
Sixth
Sixth line at?
Sixth line of the memorandum of 15/7/2019.
Yes.
Contractual.
Just before, 3 words before contractual. Just read 3 words before contractual.
967.
3 words before contractual.
Finding out of several.
Just 3 words.
Companies, corporation undertaking statutory bodies and controlled by the West Bengal.
3967.
You are reading from contractual. That is the 6th line. Just above that line, read 3 words before this. Redeploy. This is for other persons. It is a very targeted memorandum. It says boards, corporations have been wound up. Surplus staff have come into existence. So we will redeploy on these terms and conditions. You have not been rendered a surplus staff by virtue of any board or corporation being wound up. So you are not covered by this. That appears to be this.
That is the thing. He is not covered because this is due to winding.
But why is not getting 6,600?
My lord, 6,600. My lord, this is a mess of two type of circulars.
Yes.
One is 9,008, my lord, for casual workers that he has not paid. He has paid for under this circular, which is not applicable to any kind.
No, but why he is not getting 6,600? 5,000 is a very meager amount.
As per page 62.
Yes.
There are certain, my lord, conditions in that, my lord.
What condition? There is nothing. There is nothing.
In this circular, my lord.
This is for a polytechnic.
No.
And he is also working in a polytechnic.
Yes, it is, my lord. This circular, my lord.
This is for part-time. This is also for part-time. You read the second line at page 62. There is no difference. Therefore, we are asking. That is also for a polytechnic. That is also for part-time. That is also group B. There is no distinction between these petitioners and those persons. So why disparity? We understand it was not their case, but we are asking you.
That we have to take instruction. Why they are getting and he is not getting that.
You want to press this relief or you want a decision on?
on the basis of this circular part-time basis, I am get this relief. 6,600.
You want that?
Yes.
Third learned advocate for the
appearance release.
31.
March of
not you are for the prisoner. Yesterday also.
My lord, on the either matter I appeal.
Huh?
Not on this matter, my lord.
In another case.
Another matter, my lord.
Thank you.
Yes, Lordship. 32, Lordship. I am appearing. Because this is
apropos your lordship,
আমি বলে দিই একটু আমি জাস্ট বলে দিই একটু this is the matter your lordship fix the matter before the vacation bench and direction given to the lordship director of medical regarding study leave to deal with rule 175 and whether it is public interest or not. They have lordship rejected by 10th of October and lordship I move this matter on 14th of October before the vacation bench and lordship honorable vacation bench already observed in paragraph number 3 in the order sheet. Kindly see 14/10/2020. It is for public interest. That has been observed and direction given to the lordship. My learned friend to lordship place a report before the regular bench. It's- 32.
Report was to be filed. You were supposed to file a report.
yes, my lord, the report was submitted to us yesterday. And my lord, Mr. Shane, after going through that report, but we felt that the report was lacking in some of the direction that was passed on the last date. And we have conveyed our, my lord, the issues that we felt should have been incorporated in that report. If your lordship kindly grants us a day or two so that we can come up with a better report to assist your lordship, my lord.
Lordship, I am suffering from long lordship. Kindly appreciate one thing.
And we
Lordship.
could have placed that report, but that report, my lord, could not have satisfied your
Say November, 2 p.m. 2 p.m. Yes.
Well, 33, 36, 39, and 40. My lord, all the matters are identical in nature, my lord. All relates to, my lord, resignation of a doctor. And my lord, in all the matters we are banking on your lordship's decision, my lord, which is, my lord, I may say, my lord, in that matter they have already released. Now, my lord, issues are settled, my lord. The rejection orders they have passed, stating, my lord, the same old story of, my lord, dearth of doctors. Now, my lord, if your lordship takes a practical
Now, my lord, on the last occasion, as Lordship has directed me to take instruction with regard to the stand of the state. Now, my lord, if Lordship give me a week's time, in the meantime, I expect that I will get some information from them that why, in spite of the order of the of his Lordships, my lord, why they have unnecessarily issuing the same things time and again, which has been what has been fallen from his Lordship. But as of now, my lord, I have not yet received anything, my lord. So, if Lordship, with regard to this entire aspect, my lord.
Yes, my lord, is being repeatedly done. Maybe he will be able to impress upon them. Let us.
We did as
No, my lord.
today also, well, although it's not related to this matter or any other matters, today also when I received an order with regard to another doctor who has approached the tribunal, orders were passed. My lord, same rejection order. Even today, my lord. They are not sending their chant. Whatever they are saying is there. I do not mind, my lord, what Mr. Mallika said, my lord. Let that be what Vishwamitra Mallika said, my lord.
No, what we had observed in the court proceedings, and again we are saying it. It is like trying to say that 2 plus 2 is not 4. Now they have repeatedly doing this, so therefore we are thinking that maybe some consequence should be imposed for passing such an order. In the teeth of the court's declaration, if it is being done repeatedly and verbatim same orders are being reproduced, then whether it is open to the government official to behave in this way, that is an issue. So apart from instructions that you receive,
my lord,
we are just thinking aloud so that you may address on this issue also.
No, my lord, the only things is that what has fallen from his lordships, I have already, my lord, I have already explained to the department, my lord.
Therefore, we are saying that either we may not be able to required to go into this issue, or if we are required to go into this issue,
my lord,
an ancillary issue you also be prepared on. Therefore, we are telling.
My lord, lordship. I think there are identical matters, my lord. I think 33 and 36 are the same.
You are appearing in both.
In both the matter, 33 and 36,
I'm
my
led by
lord.
Mr. Shane in this matter. I am for the state.
And how many other matters?
36, 30, 33, 36, 39 and 40.
In all these cases earlier we have passed an order.
Lord, in item number 40, my lord, none appeared. Your lordship directed me to serve once more the notice. I have served that, my lord. Your lordship.
So 36 and 39, you record that. 33 and 36.
33, 36, 39 same.
33, 36, you record that.
Your lordship passed on 33 and 36.
Let the others be taken up. Yes.
42 same. Well, 40 is also same, my lord.
40, my lord, I am appearing, my lord.
Let us see. If it is, then we will pass the same order.
Date কি করব? এটা 33 আর 36 এর অর্থ না ডেট কত হবে 26 তারিখ 26
Call the other two matters.
34, can it be on 27th or 25th, my lord? 26th, my lord, I will have some trouble, my lord. Can it?
Just a minute. Mr. Malik, a different date. Which date?
Any day, 25th or 27th, any day, not 26th, my lord.
Then let it come in the next week, 1st December.
Lordship.
Yes, which are the other two matters?
39 and 40.
39. Give the file of 39. First December.
Lordship.
No, Mr. Sen is appearing. His lawyer.
Yes. I think, my lord, Mr. Sen's matter will be the first item because Mr. Sen is the, my lord, additional advocate general. So it would be better.
On that day, he will get the pre-audience. Don't worry.
Lordship.
You can convey the court's observation.
Yeah, I will, my lord. I will.
39.
39 আর 40 দাও
Or though case, the other two matters.
39
So, who is appearing in 39?
And, my lord, in terms of a lordship direction, I have once more served, my lord, the government today.
On?
On 28th, Lordship has asked me to serve by 28th. I've served by 28th, my lord.
You have served on the learned government pleader.
Yes, my lord. Government pleader's office, my lord. My lord, I do have one copy, my lord. It's only one copy of.
Then
Affidavit service was there on record. Now, this is in terms of your lordship's order. Along with the order, lordship's order has been served.
hmm? You are appearing. File it on affidavit. Not today. Can you file it tomorrow?
I have to file an affidavit, my lord.
Yes.
Yes, I will do that.
Not today. 40.
40, my lord, service, somebody appeared on
Come on, I am for the state, lordship.
So 40 same
40
order
MM.
can be passed.
Yes, yes, my lord. Yes, my lord.
40 same as 33.
Lordship.
Hey, return this. Return this. Hmm.
প্রসিড করি না বলে তো
that tomorrow, let that be day after tomorrow, but to the morning I have to inform it, my lord. I may not be, it might be the top, my lord. I will be in suit, my lord.
Tomorrow with not today.
Tomorrow not. Day after.
39.
39.
Tomorrow with not.
একদম সত্তর থেকে আর কোনো সার্চ
আস্তে 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 বললে
Point